Good morning, everybody. Welcome to the initial public hearing for the inquiry into budget estimates 2022-2023. I acknowledge the Gadigal people of the Eora Nation, the traditional custodians on the lands on which we are meeting today. I pay my respects to elders past, present and emerging, and celebrate the diversity of our Aboriginal peoples and their ongoing cultures and connections to the lands and waters of New South Wales. I also acknowledge and pay my respects to any Aboriginal and Torres Strait Islander people joining us today. Welcome, Minister and accompanying officials to this hearing. Today, the committee will examine the proposed expenditure for the portfolios of finance and employee relations. Before we commence, I'd like to make some brief comments about the procedures for today's hearing. Today's hearing is being broadcast live via the Parliament's website. The proceedings are also being recorded and a transcript will be placed on the committee's website once it becomes available. In accordance with the broadcasting guidelines, media representatives are reminded that they must take responsibility for what they publish about the committee's proceedings. All witnesses in budget estimates have the right to procedural fairness, according to the procedural fairness resolution adopted by the House in 2018. There may be some questions that a witness could only answer if they had more time or with certain documents to hand. In those circumstances, witnesses are advised that they can take questions on notice and provide an answer within 21 days. If witnesses wish to hand up documents, they should do so through the committee staff. Minister, I remind you and the officers accompanying you that you're free to pass notes and refer directly to your advisors seated at the table behind you. Finally, could everyone please turn their mobile phones to silent for the duration of the hearing. All witnesses will be sworn prior to giving evidence. Minister, I remind you that you do not need to be sworn as you've already sworn an oath to your office as a Member of Parliament. I would also like to remind Ms Campbell that you do not need to be sworn as you have been sworn at an earlier budget estimates hearing before this committee. Okay, for all other witnesses, we need you to state your full name, position, title and agency, and I might start on this side. Yes, if you could state the oath or affirmation while you do that.
Charlie Houston, Executive Director.
We might have to share microphones, I'm realising, so we can get the hands out.
Yep. Thank you. Charlie Houston, Executive Director, Employee Relations, Department of Premier and Cabinet. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Samara Dobbins, Deputy Secretary, People and Operations, Premier and Cabinet. I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Thanks very much. Michael Kurtz-Trotter, Secretary, New South Wales Department of Premier and Cabinet. I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Scott Johnston, Deputy Secretary, Revenue, New South Wales. I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Cullen Smythe, Commissioner of State Revenue, Revenue New South Wales. I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Richard Harding, CEO of Ikea. I solemnly, sincerely and truly declare and affirm the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Today's hearing will be conducted from 9:30am to 12:45pm with a 15-minute break at 11am. We'll be joined by the Minister in the morning, and in the afternoon we will hear from departmental witnesses from 2 to 5:15 with a 15-minute break at 3:30pm. During these sessions there will be questions from the opposition and crossbench members only. If required, an additional 15 minutes is allocated at the end of the morning and afternoon sessions for government questions. Thank you for your attendance today, and we'll begin the questions with the opposition.
Thank you, Minister, and welcome to your officials for here today. Minister, are you going to be introducing the land tax legislation into the spring session of Parliament?
The land tax to which you're referring, there's the Land Tax Management Act, which is already currently, of course, a bill before the Parliament.
Your proposed new changes to stamp duty and land tax?
Well, that's a matter for the Treasurer. The Treasurer has flagged the proposal in respect of the removal of the impediment to first home purchases of a lump sum stamp duty and giving first home purchasers the benefit of a choice in respect of the manner in which they elect to purchase their property. So that's purely within his remit, and I would expect the bill to be introduced by him. And of course, you'd be aware that that would be a money bill if it is introduced, and it would be introduced in the Legislative Assembly, but potentially I would have carriage of it if it comes to our House.
Correct, but you can't tell me whether the plan, what the plans are in relation to putting it into the Parliament.
I've not been briefed in respect of the exact timing of the introduction of that legislation, although I would anticipate that it will be introduced this year.
There's some confusion about this, so this is what we're trying to understand. And the bill. So you think that it's coming, but you're not sure. Is that sort of the? Well, you can't confirm.
I can't confirm the timing, Ms Sharp. I know it is part of the government's agenda, and it was certainly flagged in the budget. Yes,
that's right. And the question I'm asking is: so you're planning on going ahead before the election rather than taking it to the election?
Well, considering that there has been a debate for nearly 4 years in relation to this, no one would be taken by surprise in respect of the government's commitment to at least pursuing some sort of tax reform in the area of stamp duty, because as a tax it is one of the more aggressive taxes, and I have to say I don't think there's a financial commentator in the country that doesn't think that there is a necessity for reform in this area, and the government has certainly been out there. We've had a large consultation process in respect of it. There has been a committee charged with bringing a report in respect to the proposal, so to the extent that it represents new policy which should be taken to an election, I have to say that that would be misconceived. It would be predicated on an idea that we want to make the proposal a political issue rather than embracing reform, and I'd be saying that the time has come now to actually embrace reform. Let's make sure that we give first home purchasers the best opportunity of getting into their homes.
And so, Minister, I mean, you talk about the. There's been a lot of debate over, it's been going on for a number of years now, but there's been obviously a range of different models that have been put forward. The Treasurer at the budget said that the new tax will only apply to first home owners, but similarly the Premier has also said that he would like the tax to apply across the board. Yep. What will you be applying just the first home owners, and what guarantees are there that it's not going to be expanded?
Well, that's a question which is obviously predicated on a potential. How do we manufacture a scare campaign out of this?
No, it's a question. The Premier.
The fact is that the proposal in the budget certainly only relates to introducing legislation in respect of first home purchases. All the preceding discussion which has surrounded this issue has been a broad-ranging discussion about the manner in which we should have stamp duty reform. Now, the Premier, when he was the Treasurer, was committed to the reform of stamp duty in this state and was applauded, and should be applauded, for having the fortitude to be able to embrace new ideas. And it's something which I think we as a government should always be looking to do, is how do we embrace new ideas? Let's ventilate them, let's have discussions in relation to them, make sure that we get the parameters right, make sure that there are no people that fall through the cracks in relation to it, but let's not be afraid of reform in this area, and don't, for goodness sake, have a scare campaign which in fact stops good reform from taking place.
Minister, you don't think that pensioners are concerned about the proposition that they may have to pay land tax in the future?
Well, if you want to frame it that way, that they should be concerned, the answer is that they will clearly develop concerns. But what I would be saying to you is this, is let's do this in a way which we acknowledge that the best process is to explain properly what is happening, the choice which is available in relation to any decision to embrace stamp duty reform, whether it's pensioners or first home buyers. The duty is on all of us, not only the government, but all of us, to say this is good for the state, let's get it right.
just to be clear, so the budget papers seem to assume that the new system will apply from January next year. Is that correct? Is that your understanding?
Well, if that's what's been foreshadowed by the Treasurer, that is, in fact, it does accord with my understanding, and on that basis, I would have anticipated that legislation would be introduced to reflect the commitment by the government to that reform.
Now, I'm going to move on from this, Minister, but I just wanted to, just to be clear, the Premier's indicated that he would like to apply the tax more broadly, in fact, to everyone over time. Is that going to be included in the legislation that's provided to the House?
The answer is we will see the legislation when it arises, but it'll be the legislation which will commit the government to the process which it is involved in. But all the discussion and all the, I suppose, stakeholder consultation in relation to this has been predicated upon a principle of people having choice and electing where they will go. Now, the commitment of the government in the budget was only in terms of a first home owner or first home purchaser scheme, and I think some modelling I saw suggested that the maximum number of take-up in relation to that would be in the order of about 6,000 potential applicants in the first tranche of people who may have to or would be given that opportunity of an election.
Well, that sounds like good modelling, Minister. Would you provide it to the committee?
Well, to the extent that it's not cabinet modelling or cabinet incompetence modelling, if it is in the public arena, I'm more than happy to give it to the committee. But the principle is this: the principle is that we have committed to stamp duty reform. We are, in fact, proposing to introduce into the Parliament legislation in accordance with the commitment made in the budget. The commitment made by the government this far is that it only applies to first home purchases.
And you think it's going to be 6,000 people will take it up?
Well, I think some figure I saw suggested that...
I'm interested in these figures, Minister.
Point of order.
He's doing okay. He really doesn't need you to interrupt
I just, from the beginning, though, would like to say that this isn't budget estimates for the Treasurer. This is budget estimates to the Minister for Finance, and most of these issues that Ms Sharp is questioning the Minister about do fall with the Treasury portfolio. So whilst he probably doesn't...
He is in charge of revenue, so understanding the modelling and the amount of tax that's going to be taken is actually squarely and fairly within his portfolio.
Yep, happy to rule on this. The questions are in order.
So just reiterating the point is that in accordance with prudent government policy, what I would be saying is that we are introducing a reform of stamp duty. It is something which we have committed to, and I would say that the legislation which will be introduced will be in accordance with the Treasurer's commitment.
Thank you, Minister. You've basically said, my understanding of your policy and proposed legislation yet to be seen is that the first home buyers that are in the bottom 80% of the market are the people who will be eligible to make this decision in terms of the changes to land tax. How are you going to determine the price thresholds to determine the 20% of residential properties who will be excluded?
To Mr. Rath's point is that would probably be included in the legislation, and to the extent to which it is within the Treasurer's purview to actually draft the legislation, I'd probably defer to him in relation to that sort of question and the modelling that he would do, or the manner in which he would be drafting the legislation.
You're not going to be able to tell us in terms of we're interested obviously in the spread across New South Wales. The housing markets are quite different. trying to understand where you think that you've already indicated that you think there's going to be 6,000 potential applicants. I'm trying to get an idea of what modelling you have about geographically they're going to going to be.
And it's a fair question, and because in a sense I'm delighted that you're interested in it, and I'm delighted in fact that your interest would in fact probably run to supporting the policy. Perhaps in respect of
Don't verbal me, Minister.
Some details in relation to that, because it's better that Treasury...
Unfortunately, Mr Tudehope, that's not part of my portfolio.
Well, maybe I take that part on notice, but what I'll be urging upon on the opposition and generally the Parliament is let's not shy away from the retrogressive stamp duty tax that stamp duty is, and an opportunity of reforming stamp duty, giving first homeowners a better opportunity to enter the market, giving people an election or a choice in respect of whether they pay a lump sum or elect to pay a property tax over a period of time. I think that is good reform. I defer to the Treasurer in terms of how he will draft that legislation to make clear exactly how that will be delivered.
Thanks, Minister. My understanding is that the budget says that it's going to cost about $660 million over 4 years. Where are you going to plug that hole in how are you going to plug that hole in the budget?
Well, I'm sure you asked the Treasurer that question, and it's a question which should be directed to the Treasurer.
You are in charge of revenue, are you not?
I am.
Concerned about a $660 million
The responsibility for the budget is the Treasurer.
Okay, thanks, Minister. Minister, you're responsible for the government's procurement policy, are you not?
Correct.
Are you aware that Service New South Wales has entered into a 3-year contract with Optus to manage inbound phone services?
I saw the reporting of that, yes.
And you're aware that it's a change away from Telstra to Optus?
I assume that they have moved from one provider to another. I wasn't sure that it was Telstra who was the previous provider.
Okay. And what's your role in terms of overseeing the procurement process around conflict of interest declarations and the probity of these contracts?
The role of procurement is to set the policy parameters in relation to procurement. The actual agencies then have the responsibility for complying with those policy parameters, and I would expect that the agency itself, and I'm sure you will have plenty of time to ask Minister Dominello in relation to this, but it is his responsibility to make sure that the policy parameter or procurement policy parameters are applied by the agency.
The reason I'm asking this, Minister, is that my understanding is that Optus confirmed that the contract was won by its enterprise and business team, which is led by former Premier Berejiklian. Are you aware of that?
Absolutely.
Are you able to let the committee know, and you can come back to us if you need to, around whether all of the appropriate conflict of interest declarations were made?
Again, should defer to...
Thank you, Minister Tudehope. Ms Sharp, that procurement would have been run by DCS in accordance with the government's procurement policy framework, so I don't think those are questions that the Minister would be able to answer, other than that, the procurement framework sets the basis upon which a proper process would be run.
So could you just, then on that basis, can you at least take me through what the conflict of interest and arrangements would be required for this contract?
I wouldn't have direct knowledge of that, Ms Sharp. Yeah.
I'm happy if you come back this afternoon in terms of what the guidelines are. I'm not asking you specifically about that contract. I'm asking about what would have been required.
Thank you, Ms Sharp. I will take that on notice. Thank you.
Minister, you announced new training courses to help small business win government tenders in October last year.
That's when I was in a different portfolio. So not this portfolio.
So the procurement training for small business is not your responsibility. Is that what you're telling me?
Correct. You will recall that Minister Patinos, when she was appointed the Minister for Fair Trading and Small Business, and after she left office, I think the responsibility fell to the Minister for Customer Service.
So you have no. So even though it's procurement training, so that's it's not you. It's not your your area at all.
Well, no. I'm aware of the principle around procurement training, and it was something that I was quite keen on. Is having small business being able to procure from government.
But it's not your problem anymore.
No,
Thank you, Minister. Minister, how many applications for the electric vehicle stamp duty exemptions have been received since November last year?
In terms of the exact number, I'll ask Mr Johnson for that number.
Thank you.
In 21-22, we had 3,275 applications for EV rebates received.
And how many of those, are they all approved?
No, 2,810 have been paid. There were 278 rejected.
What basis did they get rejected?
The major reasons were they were used vehicles over the $68,750 cap to be eligible for the rebate, or they were leased vehicles.
Okay, so they're just not eligible within the criteria. And is there any, if people have their applications knocked back, is there a process that they can ask questions about that, have that reviewed?
Yes, they can do that through channels within Revenue New South Wales to consider their objection.
Do we know how many of those whether there's been many challenges? How many challenges there's been?
But I take that on notice.
Yeah, no, that's fine. I know it's a very specific question. Yeah, thank you. And are you able to tell us what the total value of the stamp duty exemptions has been? So I assume you can give it to me from 21 to 22?
I'll come back to you with that as well. That'll be easy to find.
Yeah, we can get to that this afternoon. Thank you. And have there been any changes to the eligibility criteria since the program was introduced?
Not that I'm aware of. I'll confirm that, but as far as I'm aware, that it's been consistent.
Yep. No, that's great. Minister, I wanted to ask you about the COVID fines issued to children. What's the total number of infringement notices that were issued to young people aged 17 and under for breaches of COVID orders?
I anticipate you will have substantive questions in relation to that, so just so that I can confirm the number.
Yes.
I'll start with the number that have been introduced, and I'm sure Mr Johnson has that number at his fingertips.
I do. COVID fines for under 18s amounted to 3,843.
And are you able to give me, what's the total value, dollar value for those notices?
The value for those is $2,365,360.
And can you tell me what the status of those is?
Well, I'll tell you what the status is. There are 17 unresolved.
And when you say 17 unresolved, can you give me the breakdown of what's then happened to the 3,843?
I'm sure there's no one else to ask questions, so that you can continue.
Oh, yes. Looks the way it looks. Okay. Not saved by the bell.
Yeah, no, that's okay. No. Well, I think there's a starting point in relation to this, and I anticipated that this line of questioning in relation to COVID fines for children would arise. the Commissioner is vested with large discretion in respect of vulnerable people. Children, of course, are a category of vulnerable people. So when the Commissioner gives figures in respect of the manner in which fines for vulnerable people are dealt with, it generally is against a background where he has a discretion to either waive fines, he has a discretion to come to a payment arrangement, he might have a discretion to seek to work with the young person in respect of a work and development order. And a work and development order can maybe something like attending and refereeing a soccer match, in other words. But fundamentally, of course, that revenue is a collection agency. It does not dictate how the fines have been issued. It just collects the fines, and in that regard, the Commissioner, because of what you are rightly identifying as the vulnerable cohort with which he is dealing, you are rightly asking, well, are we applying the correct guidelines or the correct discretion in respect of those fines? So I'll let the Commissioner now break up how those fines for children have been dealt with.
Thank you.
Okay, there's a few numbers here. So the total was 3,843, as I've said. So would you like the dollar value to these?
Yes, please, if you go. Yes, thank you.
Okay. So the total that is fully resolved is 3,444 to a value of $2,075,840.
So when you say fully resolved, does that mean that the fine has been paid?
Well, it could be a range of things, which I'm going to break that down
terrific.
for you now.
Okay, thank you.
So
thank you.
So 827 have been paid to a value of $415,960. Completed work and development orders, there were 363 to a value of $219,920. There are 1,965 fines that have been written off to a value of $1,204,000.
Can I just clarify, when you say written off, does that mean waived? It's a different, so what does it mean?
So written off is the when a fine progresses through its cycle of attempted contact multiple times. We make an assessment on a number of factors, which includes the situation, the circumstances for the person who's received the fine, their capacity to pay.
So is it essentially an acknowledgement that the person has no way of paying the fine?
For many, it could be that it's impossible for us to collect the money, which might be that factor, or we can't contact them or reach them, and so there's a significant number of the total. We have taken that action.
So sorry, how much was that worth?
That was worth $1,204,860. There were 7 that have been cautioned to the value of $9,000. 92 court elected to the value of $112,120. And 190 have been withdrawn to the value of $113,980. So withdrawn being different to...
explain that to me.
So withdrawn is a decision was made that this fine was incorrectly issued.
Right, okay. And who makes that decision?
Ultimately, that falls to myself as Commissioner of Fines Administration in consultation with the issuing authority, which for COVID fines was primarily police, New South Wales Police.
And we don't, so court elected, they basically go to court over it, and I assume that some of those are not resolved, is that, or are they all resolved, or they've all been dealt with?
In the simplest terms, they will be resolved from our purposes as for us to collect. It may return to us for some outcome where there might be further money.
But once they've gone to court, you wait for the outcome and see what happens. So we don't know. Okay, thank you. Do you know, have any garnishee orders been issued through these infringement notices?
Not for under 18s, no. We don't issue garnishee orders for under 18s.
18s, great, okay. And is that a policy decision, or is there an issue about them being under 18 in relation to this? Do we know?
I can it's not something we have any intention to do. I think there's legal reasons why.
Yeah.
Principally policy.
Principally a policy reason.
Thank you, Mr. Smythe. Thank you for that. Okay.
So I can give you some more numbers if you.
Yeah.
So that should have
I
added up
appreciate
to the 3,444, which I've.
Get the calculator out later. Yeah.
Thank you.
Yep.
Yeah, please do. And so then, resolved but not finalised, there are 33 on payment plans currently to the value of $24,060.
Sorry, how many?
33.
To the value of 24.
$1,060.
Quite big fines then.
Sorry,
They're quite big fines then if there's only 33 and there's 24,000.
for those ones, they average of $800 or so.
Yep.
There are 203 on current work and development orders to the value of $131,580. There are 14 outstanding. So now to unresolved, there are 14 outstanding, which is a value of $1,640. And we have a number that their work and development orders, 149, have lapsed, which we're now individually looking through them to see the circumstance, whether that the work and development order will be completed, or we have to have a look at other mechanisms,
Right, okay.
which adds to $132,240.
Great. Thank you very much.
That should all add up to $3,843.
We'll check later, but
Yeah,
thank you. I appreciate that. Minister, how many of the Dine and Discover vouchers expired without being redeemed?
Again, that's not in my purview. It is certainly, again, Department of Customer Service. I have to say that even personally, there were two that I failed to use. Inexcusably.
Well, so obviously it does impact in terms of how much was budgeted for and how much was spent. Are you able to, perhaps not give me the detail of the number that was put out and redeemed? How about the amount that was committed to and not spent?
Again, it's probably not my purview.
You sure about that, Minister?
I'm sure of that. Well, unless I'm advised to the contrary, it's not something that I had any eyes on in relation to the collection of Dine and Discover or the spending of Dine and Discover vouchers.
Okay, so you're not going to provide us with the figures?
Well, I don't have it. It's not. It's Department of Customer Service. I had no administration over the budgeting for or the delivery of Dine and Discover vouchers.
That's fine. I'll head over to my colleague. We've got lots of time because there's no crossbench. Back to 11 minutes.
Yeah, that's all right.
We've got plenty. It's fine.
Minister, in March when we were having another one of these conversations, I was trying to get a better handle on the precise nature of your role as Industrial Relations Minister in the government, and I think you said, I think it was page 16 of the transcript, that your chief role, as you said, is to ensure industrial harmony is maintained, but
I'm not doing a good job of that.
well, I'll come to that point.
Clearly.
Well, I welcome that concession. But you said, to the extent you're suggesting I ought to immerse myself into the negotiation, I'm a bit reluctant to do that. And the impression I got in our conversation was, very much, you're there in a support role. You're not a sort of hands-on like the portfolio ministers in terms of, the nitty-gritty of industrial negotiation, but things seem to have taken a turn for the worse. You seem to have had quite a bit of involvement in the rail matter. How and why did that happen?
Well, the how and why is potentially because of the inability of the unions to adopt a consistent and clear position in respect of trying to reach an outcome, and the Premier directed that I do have a more hands-on attitude in terms of ensuring that government policy and bargaining parameters which were approved by the government were adhered to by agencies in terms of making sure that we had a consistent government position which was to be used for the purposes of negotiating with the unions. Now, in respect of the rail union, as you would probably appreciate, this is a union which never has a consistent position. So whenever you reach an agreement with them one day, it changes the next. And to the extent that I have had more profile in these negotiations than potentially other negotiations which have been ongoing, and I'm sure of which you're aware, that profile has been, A, because we have had to try and get a consistent government position agreed to, and a position where we can reach a new enterprise agreement, and we are dealing with a union who consistently moves the goalposts in respect of the outcomes that it is seeking to achieve in relation to both the enterprise agreement and the I suppose the terms that it wants to achieve. Now, well, I don't seek the profile, Mr. Searle. I can tell you, I would prefer to have no profile in respect of this, but I do expect that agencies and unions would negotiate, and the government would negotiate in accordance with the bargaining parameters which are set by the government, and to that end, I do have a role to play.
Okay, well, we'll come back to the bargaining parameters, but surely it seems that the Premier's direction for you to become involved was really a sort of a vote of no confidence in the portfolio minister. I mean, the minister himself, just a few moments ago in another room, said his frustration with the intervention of colleagues such as yourself and the Treasurer into the process was a matter of public record. So surely the Premier's direction for you to become involved is really a vote of no confidence in the Transport Minister.
Well, no, quite the contrary. In fact, I think it's a reflection of the fact that this was a recalcitrant union.
Well, okay, well, come to this.
But that's an important point.
Well, no, see, the point you were making was about your involvement because the bargaining parameters weren't being adhered to in relation to enterprise bargaining, but the key driver of this dispute has been the issue over the safety of the new the NIF, the new fleet, and whether the government was going to make adjustments. That had nothing to do with wages and conditions. In fact, it's your government that has sought to conflate the two as part of the new deal.
Quite the contrary. It was the union's position that in respect of the employment agreement, they wanted the position in respect of changes to the NIF to be included as part of the employment agreement negotiations. It was not our position, and in fact I made it very clear very early on that I thought the safety issues that were being raised by the unions in respect of those negotiations were entirely wrong.
But the government's now conceded that.
No, they haven't.
You'll be making changes, though, won't you, to the fleet?
And the rationale for that, Mr. Searle, is this.
That's a climb down on what the government was saying.
And the rationale for that is that we value the commuters of this state in terms of their ability to get to work and to make sure that the economy of this state runs. Now, any concession we have made in relation to that, any concession is not predicated upon an acceptance by the government that this work needs to be done. It is predicated upon a view. It is predicated upon a view that we value the commuters of this state, which is something that this union does not do.
That's an outrageous assertion.
Well, and it reflects the facts.
The travelling public front and centre in this matter.
It reflects the facts. The facts are.
Point your finger, please.
You pointed at me.
Wow.
It reflects.
I withdraw.
It reflects the fact that this is a union which does not value these commuters. Any union which is content to see people squeezed onto trains cheek by jowl, onto platforms cheek by jowl, does not have any regard to safety of those people. Any union which in fact says that safety issues are conflated with whether there is a spilt can of Coke or chewing gum on a seat and doesn't. Are you pointing at me now? Sorry?
Those are your words, Minister.
No, that they are in the public arena, Mr. Searle, that these are the things that the union is saying are reasons why they would not drive a train this morning. There were 700 odd services this morning which were cancelled because a driver turned up to run a train this morning and decided that they would not run the train for either a cleaning reason or other, what they say were perceived safety reasons. Now, they're not decisions which the government made. These were members of the RTBU saying to the public, we don't care if your train turns up this morning. We don't care whether you get to work this morning. We don't care whether the small business...
That's not the position of the
It is the position, Mr. Searle. No other construction can be placed on a strike which occurred today in terms of drivers making decisions about running those trains other than they have no regard to the commuters of this state. Now, any concession which the government made in relation to doing work on that fleet was primarily based not on the fact that we conceded that that safety work needed to be done, but because we wanted the commuters of this state to have a reliable transport service, something that this union thumbs its nose at.
Minister, are you seriously saying here on your oath that the government is contemplating spending $250 million or more adjusting this fleet in circumstances where it doesn't agree that that work needs to be done?
I am seriously saying that on my oath.
That would be a ridiculous position.
Well, I'm saying on my oath that a concession has been made because we want industrial peace in this state for the benefit of the commuters of this state. The Office of the Safety Regulator has approved this fleet of trains to run on this within New South Wales. These trains run in other parts of the world without these modifications. Now, what is occurring here is that this union, which funds your party, by the way, and your election campaigns, by the way, is conducting a hostage circumstance for the government where it is seeking alterations to an employment agreement predicated on industrial chaos.
I'll move to another topic,
I'm
Minister.
sure you will.
No, Minister, this morning the Transport Minister again recommitted that he had no plans to cancel the existing industrial agreement with the RTBU. But it has been reported in the AFR of the 10th of August and in other places that you have consistently kept that on the table as an option.
Yes.
So what is the government's policy? The Minister's saying there's no plans to cancel the agreement, but you seem to be saying that that remains under active consideration.
Well, it's part of what is available to the government in the way that it deals with a consistent process where this union causes such problems for the people of this state.
This is bad cop, good cop. So what is the government's policy? Are you considering cancelling the agreement or not?
The government's policy is that this remains part of the process. If we need to go to the Fair Work Commission to get a resolution of this, this may be something that we can avail ourselves of. But let me just say in relation to that, we've always given a commitment that if we go down this path, we will do it in such circumstances that there will be no wage losses for any employees as part of that process. What we are dealing with is potentially an agreement which is causing the train system in this state not to be able to run properly, where strike action is consistently being used to thwart commuters being able to get to work, and it must remain. It must remain as part of something which is available to the government in those circumstances. Must remain.
Must it?
It must. And in fact, I notice that your federal colleagues are going down this path of being able to remove the right of employers to terminate employment agreement. You would know that 96% of applications for the termination of employment agreements are uncontested. Well,
usually because there's a new instrument to be put in place.
And
not used to sort of put wages and conditions into free fall to cut.
But I've just explained
which would
that
be
to
the
you.
legal effect of your proposal.
I have just explained that to you. I would not allow that to occur. It would be against a background where we would give a commitment that wages would not go into free fall.
Minister Elliott also said that other radical proposals in relation to the workforce were being considered as part of this. Can you outline to this Estimates Committee what other radical proposals your government's considering the context of this?
No, if Mr Elliott has ideas relating to radical proposals, they are purely a matter for him. But as Industrial Relations Minister, I only use the levers which are available to me, and I get advice in respect of where we would go in respect of ensuring that the commuters of this state are front and centre of what we do. The commuters are, and not union bosses. And now, if you want to go down the track of standing up for the chaos which these union bosses are causing, matter for you. But I have to say that will never be the position of this government.
Keep going. Can we keep going?
Your position.
Okay.
It's all us.
Okay, well, this is good.
It's all you.
Well, you talked about, going down that track potentially and going and making an application, presumably, to the Fair Work Commission. But the last time you were down there, the tribunal talked about the government making inexplicable claims about harm to the New South Wales economy, and basically your application was unsubstantiated by evidence that was hard to fathom. How is it that with all the sort of support of the Department of Premier and Cabinet in fulfilling this role that you have, that you're able to mount such a poor argument? It really didn't seem to have any merit, did it?
Well, Mr Searle, you and I can agree on or disagree on the merit, but you'd also agree with me that having been a lawyer in practice for many years, always someone loses. And when someone loses, they regret losing. I have to say that an application to terminate was not the same as an application to suspend protected industrial action. A different set of evidence and circumstances would be relied upon in those circumstances.
But you've had access to some pretty good legal minds. I see you've had a significant number of barristers acting for you. You've got the Crown Solicitor's Office, which also has a wealth of experience. You'd have internal legal experts from Transport for New South Wales as well as DPC. How did you all get it so terribly wrong?
Well, I have to say that potentially at the end of the day, I'm not convinced that we did get it terribly wrong. The decision certainly went against the government, and the Commissioner was not satisfied. Commissioner Cross, as I recall, Deputy President Cross was not convinced of the economic impact or the manner in which the impact of the protected action would in fact impact on the economy. I happen to disagree with that, but he is the Commissioner at the end of the day, and you and I can agree. You and I can agree that we ought to all abide by and respect the decisions of industrial relations umpires.
Absolutely.
And in fact, you'd be agreeing with me that if they're not respected, then in those circumstances there ought to be penalties which flow from not respecting those umpires' decisions.
Well, there are already.
But they ought to be effective.
Well, that's a matter of discussion, isn't it? Minister, so I couldn't see in the budget papers looking at budget papers.
Just while I'm on it, of course, you do accept, of course, that one consequence of taking that protected industrial action was that the union did, in fact, pull back on some of the industrial action that it was in fact foreshadowing at that time. So the process of actually engaging in the application to the Commission did deliver some significant benefits in terms of reaching agreements on moving away from some of the protected action which was occurring.
I'll have to take your word for that. But Minister, I can't see anything in the budget paper about the Industrial Relations Office or whatever has replaced it. So who are these highly skilled professionals that you rely on for your support in?
Three of them are here.
I understand that. I mean, Mr. Coots-Trotter I know well, and Mr. Houston, but I mean, presumably there's more. What is the budget that underpins this function within DPC? Or maybe Mr. Coots-Trotter's best to answer that.
Broadly across the employee relations function, which includes, of course, important compliance work around long service leave, aspects of the transport industry, and some issues coming out of local councils. I think, Charlie, you reminded me this morning we had about 50 people engaged in that function, but I'm happy to pass to my colleague Samara Dobbins or Charlie Houston for more information.
Houston.
So the employee relations function sits within the Department of Premier and Cabinet. Yep. The budget for the area is in the order of $8 million a year.
Sorry, 8?
8 million, thereabouts, fluctuates a little bit from year to year. In terms of staffing, we have about 50 full-time equivalent employees. The largest portion of that is, as Mr Cootstrotter mentioned, is engaged in compliance work. That's about half of the area. We also then have a public sector team within that, and also a policy team.
And how big's the public sector team?
About 14 people.
Okay. And is that the team that works in relation to live industrial matters like the rail dispute? Or
that's correct.
And so that's your...
That's part of the function. There's obviously, we divide up the work as per portfolio areas. So
it's about 15 people that work in that sort of space? Okay. And what's the budget? Is it just pro rata, sort of 15 divided by 50 times 8 million gives us roughly the...
We don't budget down to that level.
And apart from the directly employed people in this area, do you engage outside consultants to assist with this work or provide advice in relation to
Not with this work. We do engage some externals to help with the development of, might be educational services. Like, for example, we develop e-learning type modules across the area that are published and available publicly through our website for people to learn about public sector industrial relations or appearing before the Commission and the like. But in terms of expertise in and advice on employee relations matter, that's a matter which is generally dealt with internally with the assistance of Crown Solicitor's Office.
I know you said generally, not trying to be tricky, but does that mean sometimes you do engage outside consultants to assist with this work?
Rarely, but it does happen.
Have you done so in the last year?
Yes.
Have you done so in relation to the rail dispute?
I might have to take that on notice, I think.
Happy for you to do so. Minister, I note that I think at the last count some 80 awards and agreements were due to expire at the end of June. Apart from the rail matter, what other of those matters are you actively being engaged in with the assistance of DPC?
Well, actively engaged in the negotiations, other than, I suppose, ensuring that wage policy is adhered to. I've had meetings with the unions and representatives, certainly in relation to the health unions. I've had meetings with the teachers' union, not in terms of a participation in the negotiation, but more as getting to know you session, to understand that I do have a role in ensuring that the government's bargaining parameters are adhered to, one of which will always include our wages policy. And generally, those agencies conduct and have conducted the negotiations with the unions fruitfully. I receive updates from Ms Dobbins and Mr Houston on a fortnightly basis in terms of where things are up to in relation to those negotiations. And interestingly enough, generally there has been not the level of position changing in respect of those unions as there has been in respect of the RTBU. Now, read into that what you will, but there seems to be an absolute recalcitrance by this union specifically.
Well, Minister, I'm not asking about that union. I think you're taking a bit of a liberty here. So perhaps we can ask.
But it is a comparison worth making, Mr. Searle.
Well, I think we can assume you've already made that. How many of those agreements, the 80 odd that had expired at the end of June, have been renewed?
We can take that on notice, but just as a general guide, around more than half of the public sector employees are now subject of recently remade awards that include the government's wages policy.
Now, I know, Minister, you said that the wages policy was, one of the government levers or policies, in this industrial relations space. The last time we had a discussion here at budget estimates, I think it was your evidence that the only really overarching industrial relations policy this government had was the wages policy. So has that changed since March? Do you have other sort of policy instruments or tools other than the wages policy?
Well, all agencies have different work conditions which they would need.
Other than conditions, in terms of tools with which you approach bargaining and manage the workforce.
Well, one of them, of course, would be our approach to productivity, which in the second year of the wages policy allows the government to work with unions to identify productivity outcomes.
I'll just take you up on that. That's where an additional 0.5% is available on top of the original 2.5%. That's correct? That's what you're referring to?
Yep.
So how is that extra 0.5% to be accessed by workers collectively? I mean, what is the policy parameters around accessing that other 0.5%?
What I would be saying to each of the individual unions which are bargaining on behalf of those public sector, identify what you say are productivity enhancements. Now, in respect of the HSU, for example, some productivity enhancement may in fact involve a rewording or reworking of a plain English employment agreement. That may in fact be a productivity enhancement, but what we effectively are saying to the unions is identify productivity outcomes and come to us with those productivity, what you say are productivity enhancements.
Well, what I'm asking you as the relevant minister is how will the government evaluate productivity propositions?
Well, let's assess them as they arrive.
Well, I'm asking you how you will assess them. Like, what is the policy by which you will evaluate any proposals? Because, to be fair, Minister, without setting that out with clarity, you're not really giving workers or unions a clear guide as to what might be acceptable in terms of counting towards that.
We are saying to them that there is a 0.5% available to be accessed by each individual employee group, and it is up to the union to identify the productivity enhancements which they say that they can identify to achieve that additional 0.5%.
Yeah, well, let's assume they do that and they come to you with a proposal. How are you what are the tools with which you will evaluate those propositions?
Well, I know that the unions are adept at identifying what they would
I'm
say.
not asking about I'm asking how the government... Seriously, if you're asking people in good faith to think hard, to develop meaningful proposals and come to government, they have a right to know how the government is going to evaluate that. That may influence the proposals they put forward. Yep. It might influence the way in which they package different ideas together. Yep. But if they have no guidance and no ideas, it sounds like you're just plucking it out of thin air.
No. Except that we have the benefit of the IRC to be able to assist us in identifying what is a productivity enhancement.
Well, at the moment,
in fact, that's a useful tool to have, is the IRC to be able to sit between the parties and assess whether a particular proposal meets a productivity enhancement. And what I'd be saying is, I'm sure Mr. Houston will correct me if I'm wrong in relation to this, but we recently identified a potential productivity enhancement in respect of the fireys, where individual workers there were able to carry out additional use of what they were using, I think, ventilators to assist. There was some additional training which members used for the purposes of emergency circumstances where that was identified as a productivity enhancement, engaging in that extra training and the like, and that was for the purposes of reaching an agreement. Something was identified by the union for the benefit of their members, and I would be saying to those negotiating, come to us with what you say is a productivity enhancement, and if it truly is a productivity enhancement, or the IRC rules that is a productivity enhancement, they're the facts and circumstances on which the employees would be entitled to that additional 0.5%.
Just correct me if I'm wrong, but it was the case, wasn't it, when the government originally adopted the wages policy, that to do better than the 2.5%, productivity gains had to be identified and put to government, because the government's position was always you could do better.
No, I think savings was a better way of looking at it.
Yeah, I was going to say it was dollar for dollar savings.
Indeed, there had to be.
So, these additional proposals had to yield real, tangible, identifiable dollars and cents before you could get beyond the 2.5%. That's correct?
Yeah, so that was under the previous wages policy.
So
there had to
is
be.
that the same metric by which you're going to measure
is the short answer.
proposals for the extra 0.5%? No.
No, is the short. Are you able to?
No, so the previous policy, the constraint in the previous policy was that you had to identify and deliver upfront savings to employee-related costs before you could get access to a wages settlement above 2.5%. The change in policy is the features of the new approach are the constraint is the agency's forward budget, but that is the whole of the agency's forward budget, not just its employee-related expenses. So if either management approaches staff and unions or the unions approach management with a proposal that adds to the productivity of the agency, it does more within its existing budget, then that could attract the additional 0.5%, but it has to be paid for within the agency's total budget. So it's a loosening of the constraint that applied to the previous policy. It encourages a broader range of ideas about how you might improve the quality of the service, make for a better a climate for staff, but it has to be paid for within the forward budgets that have been set in the 22-23 state budget.
Okay, so I guess my question again is, I think taking your evidence that it allows for a loosening of the approach and a wider range of proposals to be put and considered. Is there a government document that sets out how those matters are to be approached and evaluated?
I can invite Mr Houston to go to greater detail if you want it, Mr Searle, but we're in the process of working across agencies to identify some ideas and initiatives that will bring to government and then take to industrial parties and staff as a starting point for discussions. But if you wanted some more information on that, I can...
Can you enlighten us further as to how these matters are going to be evaluated by government?
So in short, we have an established process for dealing with bargaining proposals, and this would be a similar category. So as options are identified through agencies, they would bring that to the Senior Officials Wages Advisory Committee, which consists of representatives from DPC and Treasury to review and evaluate those proposals, which, once that's occurred, would be referred to the Expenditure Review Committee for approval.
Assuming this sounds like a better idea to, loosen things up a bit and encourage a wider range of ideas to come forward for workplace change that benefits the workers, why didn't you adopt this earlier?
Well,
how and why did this additional idea come about?
Oh, it's got a good industrial relations minister. It's,
it predates you.
No, the good ideas have only come with me.
Is that right? So this is your policy.
Without being flippant in relation to it, it was self-evident that that in the current economy that there needed to be a long look at our current wages policy. The wages policy that we had...
It would have been too stingy, like wages...
No, in fact, it had been too generous. In fact, for the 10 years in which that wage policy had been in place, it had delivered real wage outcomes for the public sector which were way ahead of the inflation rate, way ahead of the private sector wages increase, and in fact, in real terms,
over 5%.
I beg your pardon?
Inflation is now running at over 4%.
Well, and that's part of what we needed to take into account in terms of where we are in terms of moving the parameters in relation to wages policy. But we don't want to be, and you'll agree with me in relation to this, I'm sure, Mr. Searle. We don't want to be a contributor to inflation. We want to be a solver of inflation.
Minister, taking up the point that I think Mr. Coates-Trotter and Mr. Houston were mentioning about some proposals being developed and brought forward to the industrial parties, are you able to enumerate or identify at least the kinds of proposals that you're considering? Or is it too early?
Prospectively, no, because I haven't seen them, but perhaps to give some examples of things that have happened previously to possibly illustrate the point. So examination arrangements were changed in concert with the relevant union so that HSC markers did their work in a different way and were, as a result, more productive. There were a range of changes, operational changes within the police force, which enabled a pay rise above prevailing wages policy at the time, new technology at Port Kembla, which increased the efficiency and productivity of the port, allowing for pay to rise above 2.5%. They are examples from recent history. But really the government's new policy does allow a deal more creativity, because you don't have to link it solely to savings to employee-related costs. You can look at other benefits that are available to the community, and we, wait with interest to see what colleagues across the sector come in with.
So who's generating these proposals? You mentioned colleagues across the sector. Is that IR people in the different department agencies? Well,
I would assume it would actually, in concert with IR people in different agencies, but it would be functional leaders who would have, a better understanding and insight on the kind of things that they could do in their area.
Okay.
They'd, I'm sure, take specialist advice from their IR or HR teams, but I would imagine it's people who have responsibility for delivering public services from the front line.
Okay, and are you able to say which agencies are actively engaged in this process?
I would hope all. So we've been discussing with agency cluster representatives about the development of proposals. It's still an early stage at this point, but we hope to be in a position later this year where we have some clarity on what sorts of things might be able to be progressed further.
And to give them that guidance, is there like a Premier's Department circular, or is there a document that we can have a look at that sort of sets out the kind of agenda you're setting?
Not at this stage.
Okay, so at this stage, am I to understand, or is the committee to understand, that these are verbal discussions only at this reasonably high level of abstraction that we've been discussing here?
Well, to an extent,
things are either put in writing or they're not.
There is some documentation in terms of, for example, a letter to agencies saying we welcome your ideas about productivity enhancements. There was some reluctance to provide detail at an early stage that might then operate to confine things unnecessarily. So as a starting point, we thought it was of value to hear all the ideas before narrowing anything.
Okay, and this is happening outside any IRC supervised process. This is something that you're driving at departmental levels. Yeah. And you mentioned productivity, Mr. Houston. I think Mr. Coates-Trotter, if I didn't misrecall, I think you used the word creativity. I assume these aren't terms of art. These are sort of ordinary English language words that you're sort of impressionistic, not subject to any kind of particular rigour. You want to sort of bring forward ideas and sort of evaluate them in the light of what is put to you.
Yes.
Okay. I'm just trying to get a sort of sense of the process and how it's going to work.
It's a fair call. I think there's some work to be done. And one of the things that we would expect is the unions and those who represent the various public sector unions to make a contribution of what they think productivity enhancement and contribute to that discussion.
Well, just on this, on the last occasion at budget estimates when we were having a chat about, I think there was a level of industrial unrest. I think we discussed that there'd been nurses, I think teachers, you had other health professionals. The doctors have launched a significant underpayment of wages case against the government in the Supreme Court. There's the rail matter. Some of these matters aren't to do with wages as such. These are to do with other conditions of work, the issue about adequate staffing, work hours, that kind of thing. And I invited you to consider that maybe looking at this in the sort of narrow frame of the wages policy only and wages discussions, that given the root causes of a lot of these matters were not particularly wage related, and you should take a more sort of root analysis approach. In that context, I note your Industrial Relations Advisory Council doesn't seem to have met since 2014. Isn't this a useful role you could have used that body to engage in, to sort of try and bring together sort of an analysis of what is driving a lot of this difficulties in the workplace?
I hear what you say. I'm well advised in relation to industrial matters, and
you don't need the Industrial Relations Advisory Council.
I've just been handed a note, so I'll have a look at that in a minute. But
I think a review in 2016 suggested that council was no longer fulfilling a useful purpose. So are you going to reactivate it, or are you just going to let it sort of drift?
I'm happy to take advice in relation to the necessity of that. But just can I just indicate to you about what you indicated were the level of industrial unrest which you identified when we were last here, and you've identified a lot of workplace conditions in respect of things which were agitating a lot of the public sector workers. One of the things you didn't identify, of course, was that the Secretary of the Labor Council, in a political way, called this the year of the strike. So there's a political motivation which is sitting
before the horse,
which is sitting well behind this. But let's not but you've identified a series of issues which, and I don't necessarily quibble that they are front and centre issues but there is, certainly in respect of a number of the industrial campaigns which have been launched, a political purpose which has been motivated by the New South Wales Labor Council, your colleagues who are out there agitating for industrial activity.
If people are being overworked and not rested between shifts.
I get it.
Okay,
I get it.
we need one person at a time.
I get it, Mr. Searle.
Need to keep a record of this.
You're up for pre-selection. You need to be able to satisfy those union bodies which are instrumental in your pre-selection. I get it. But the fact of the matter is that there is a political component to a lot of the industrial, and I don't say for one minute that there are not legitimate workplace concerns that some of the unions have identified as being front and centre for their employment agreement negotiations. But there is certainly, and I have to say, let's get it on the record, since you've put it on the record in relation to all the other issues, that there is a political component involved as well.
Well, what I'm asking you to reflect on is, last time I asked you, given that a number of these concerns in different public sector workforces were not wage related, they related to other conditions of work such as overwork, excessive hours, not being paid for the hours worked and the like, wouldn't it be better to look at these in a sort of global and systems way to address those underlying issues, rather than looking at it through the narrow prism of the wages policy and wage bargaining only?
And I expect agencies would in fact be, on an individual basis, be negotiating exactly along those lines.
You're the IR Minister or the Employee Relations Minister. You get involved when things are not being addressed as they ought to be in the view of the government. Why aren't you getting yourself involved to make sure that there's a systems approach here, and that the root causes of these matters are being
generally the agencies conduct these negotiations and report back to me on a regular basis, and I have utmost confidence in respect of the manner in which those issues are being dealt with. But you would agree that every agency has its own set of workplace conditions. Now, if I look at one thing, one of the issues which the nurses have raised is in relation to ratios. Now, I do note that your side of politics has walked away from supporting nurses' ratios, and yet it is still under active consideration by the union, and they are still pressing for that. So I would expect in the circumstances you would join with the government in saying that that's not the appropriate way to, in fact, resolve that issue with nurses, that there needs to be something else which needs to be done in relation to making sure the work hours for nurses are correct. So,
well, there's a whole issue of workforce constraints right across the health services.
And what we have done is, and you will see in the budget, the commitment that the government has made to making sure that we, in fact, relieve some of those workforce pressures by, in fact, funding the additional places for nurses and healthcare workers.
I think the government said you were going to employ, was it an extra 7,000 workers in was it the health sector? Or was it
I don't have the figure available, but I recall it was substantial.
Yeah. How's that going?
Oh, you'll have to ask the health minister in relation to that.
Okay.
What is important, though, and I'm sure you'll agree, is that we have funded it.
Well, have you? Have you?
Well, it's certainly we have.
Minister, today the Federal Industrial Relations Minister was talking about the cancer of gig work and the difficulties that it causes for people who have no options but to work in that space. And you'd be familiar with the report of the Upper House on the impact of technological other change on the future of work. And the evidence before that committee on which I served was quite clear that gig workers have no capacity to bargain. There's gross inequality of bargaining power between themselves as sessional workers and the multinational platforms that they engage with. They have no legal minimum pay, no sick pay, no superannuation, and no workers' compensation. And in some of these situations, there have been very tragic outcomes, not only in terms of gross exploitation and underpayment, but also people dying at work and safe work having a fairly tardy response. What is your government doing to respond to the recommendations made by that inquiry or the issue in general?
We'll be delivering a response to the inquiry in October in accordance with the government's commitment.
Okay, and can you tell us whether, as a result of that, the government will be making any changes to the proposal?
Well, it'll be interesting because I think the part of the report would seem to suggest that a lot of the issues which you've identified and which the majority identified are largely within the ambit of Commonwealth jurisdiction. Now, you might suggest that there are other things that we can do as a state government.
Well, there are, because while employee relations is largely now governed because of the corporation's power by the federal parliament, gig workers aren't employees, which is rather the problem for them. They don't have employee rights. And because of that, it would be permissible for any state to regulate or legislate should it choose.
Well, I must say that's your view of it, but my view is the Independent Contractors Act actually expressly prohibits states from legislating for rights and entitlements of independent contractors.
That's if they're independent contractors.
Well, isn't there a High Court decision which has just found that where there is a contract which spells out the rights of then the High Court has said that they will consider them as independent contractors.
Well, that's a fairly new development, but it also raises the problem for those workers.
But it is being implemented by the Fair Work Commission. So, to the extent that the federal government says that they need to intervene, that's probably consistent with the view of some members of that committee that this is specifically a Commonwealth responsibility. But as a matter of principle, though. We've got to be, while I am very cognizant of making sure that people who work in that industry, in the gig economy, do have work safety entitlements and do have an entitlement to have a safe practice system of work. What I would be saying is that the nature of the gig economy has created opportunity as well as some of the difficulties that you've identified. So what I would be saying to those who are considering this question, and I'm sure it will be raised next week in another forum, what I would be saying is whilst we have a responsibility to make sure that people are not placed in an unfair and unsafe system of work, let's not in fact also kill a model of work which in fact for some people and for some employees has provided an opportunity to work, whether it's students or whether it's people who want an extra job or the like. Let's make sure that we don't kill that opportunity for those workers.
Well, the inquiry found that the majority of people working in this space wanted more hours. They were looking for permanent and stable work. It wasn't, the part-timers, the students of the kind that you're talking about. These were people looking for proper, stable incomes.
Yep. I don't quibble with that.
You're not advancing the proposition, are you, Minister, that in the 21st century, every worker shouldn't have a minimum rate of pay, are you? Or that you shouldn't have entitlement to sick pay, workers' compensation?
I predicated my view to you that they have got to be treated fairly.
With legally enforceable minimum conditions.
Well, how that is spelled out is going to be a matter.
Can you?
Of course, I'm a great believer that people
workers to have legally enforceable minimum conditions do.
I'm a great believer that people who, wherever they are employed, must be treated fairly and have a safe system of work.
I think that's probably the best I'm going to get from you on that point. Wage theft. Do you accept that wage theft is a problem that needs better addressing?
Well, of course I do.
In fact, you said that in the second reading speech on the Tax Administration Amendment combating wage theft bill, didn't you?
And I haven't changed my position, Mr. Singh.
No. And there was an inquiry into that legislation which reported to the Upper House in June of last year. But the bill has been sort of left languishing like an orphan. So although there were criticisms of that bill about it not really tackling wage theft, you haven't even progressed your own fairly weak proposal.
Well, I thought they were strong proposals, and what we sought was an agreement with your side of politics that you would not amend that bill because it delivered real benefits in terms of making sure that those companies, that weren't paying their fair share of payroll tax were identified, that there was transparency in relation to people who had avoided payroll tax, and that there was an opportunity to share information in relation to the non-payment of payroll tax. Now, that was what we thought was imminently supportable legislation. What we had always and have always taken the view is that wage theft is an issue for the Commonwealth Government to deal with. We have pressed that, and in fact in recent discussions I had with the Federal Industrial Relations Minister, he has indicated that he will be bringing forward a federal bill in relation to wage theft, and in those circumstances we would hope that that covers the field in respect of the issue.
But the criminal law of the state has always been governed by state legislation. Are you willing to cede state criminal law sanctions to the Commonwealth?
But you would be aware that many of the corporations who have been involved are cross-jurisdictional in terms of their reach and where their employees are. What I would be saying to you is that the appropriate place, and the Federal Minister agrees with this, is that the appropriate place for wage theft legislation to be developed is by way of a federal law, which in fact covers corporations generally who work in circumstances where they are paying payroll tax and where they are not meeting their commitments to their workers.
Well, the attitude of the Commonwealth has only recently changed with the change of government. But
I
took
quibble
action
with
long
that.
ago. Queensland's taken action, but New South Wales.
And how many prosecutions are successful in those jurisdictions?
It's about changing culture, isn't it? Isn't it about,
Well,
it's about naming the behaviour you don't want people to engage in.
Pass our legislation as it currently stands, without amendment and without amendment.
I don't accept that there was an agreement about that. I'm not privy to any such arrangement, but the point is, but you won't even bring it forward for debate.
What I'm saying to you is give us a commitment that you will pass the legislation in its current form, and in those circumstances, I will lodge it in the first sitting week. I will debate it and pass it.
But why are you frightened of a debate?
What I want is the commitment.
That's the parliamentary process.
Why won't you give us a commitment? Why won't you give us a commitment that you identify the legislation that we are proposing as worthwhile legislation, achieves a lot of the outcomes that you would like to see achieved in terms of the responsibilities of the Office of Revenue, and in fact use that as a tool.
Minister, the upper house doesn't give governments a blank cheque, and you know that.
Well, but there is an opportunity to identify good legislation,
Minister,
Mr.
I can ask you this question. The bill does not require Revenue New South Wales to use its assessment of payroll taxes to work out if employers are paying correct wages. It's all about payroll tax. It could be enhanced to give Revenue New South Wales an enhanced role in terms of identifying wage theft and then notifying relevant authorities. Why won't you accept that sort of change to the legislation to improve it?
Well, generally, as I understand it, is that the circumstances in which underpayment of payroll tax arises, and perhaps the Commissioner or Mr. Smyth might be able to elaborate on this, but it does identify circumstances where corporations have in fact faced prosecutions, or where it has been identified through the Fair Work Commission that there has been underpayment of wages, then that information then triggers an opportunity for an investigation by Revenue about the correct payment of payroll tax. Now, that's a worthwhile thing, but what I would identify for you is the sharing of information between the Tax Office, the Fair Work Commission and Revenue is an important component in identifying potentially corporations who are not paying their tax, and the appropriate way to do it is to share the information with the enforcement authorities, being the Fair Work Commission or the Tax Office, rather than in fact use this as a blunt instrument to identify wage theft when the Commonwealth is the appropriate jurisdiction to do that.
The Fair Work Ombudsman in the past identified the problem is one of actually detecting wrongdoing, that even with enhanced resources, even with complaints coming forward, there weren't enough resources in the federal regulator to actually identify all the wrongdoing. So it sounds like
they
always need
they need to resource
help they can get. So why wouldn't in this legislation you make it clear that Revenue New South Wales, apart from assessing and identifying under and non-payment of payroll tax, would also identify non-payment of appropriate wages and refer that to the relevant authorities?
I think the legislation does in fact encompass that. Well, have a look at it.
The committee said this wasn't that clear and it can be enhanced. So
I have to.
Why are you resisting that process, Minister?
It's my understanding that the legislation does in fact achieve that purpose.
Well, you say it may achieve that purpose, but if it's not clear, why are you resisting enhancing the legislation so that is abundantly clear? Including the sharing of information.
I think that what is envisaged, Mr. Searle, is not only sharing or clarifying the sharing of information, is to actually create criminal penalties.
Yes, well, of course, that's the other shortcoming in the legislation. It doesn't actually criminalise wage.
No, because that's the appropriate jurisdiction of the Commonwealth to do.
30 seconds.
I was about to get onto the issue of the gender pay gap. Recently, I think it's in August, the gender pay gap nationally has been identified at being something around 14%. In New South Wales, it's 12%. On the last occasion, we were discussing the state of the New South Wales Public Sector Report 2021 and about how the gender pay gap across the public sector has, again, I think for the third or fourth consistent year, deteriorated. And I was asking yourself and Mr. Cootes-Trotter about strategies and actions to to reduce that. Leaving aside the issue of gender segmentation, which I know is a big problem, what are you doing to make sure that, in the SEB branch that, men and women are getting, equal pay for doing equal or comparable work?
Yeah, well, I'll pass that to Mr. Kurtztrotter.
So we've had discussions between secretaries. We've looked at the data, particularly in more senior roles, where there does appear to be a continuing gap. From memory, the gap was about 4% on the last report. So it was a bit volatile from memory in the last report. It had been fairly consistent prior to that and consistently lower. So I think we've asked the question, and my colleagues are having a look within their organisations to see if they can better understand why it bounced in the last report, and we've got another report coming up later this year. So I'm more than happy to take the question on notice and come back with any specifics that my colleagues might be able to provide.
Morning tea break?
It is. So we will now break for 15 minutes for morning tea, which will bring us officially back at 11:17.
All right.
Welcome back, everybody. We'll continue questions with the opposition.
Good to see you, Minister.
Mr. Mookie, it's always a pleasure to see you. And in fact, I was disappointed when you weren't here when I arrived. And in fact, a question of your priorities arises when you elected another minister to go and see before you were elected to come and see
Minister,
me.
Look, I'm going to say I did miss you. And I've got to say, it's clear that absence has made your heart grow fonder too. So.
Sure. To the extent that these sessions often involve a character assessment of you and I, let's keep it civil, and you ask the questions and I'll give you the answers, and you won't interrupt me and I won't interrupt you. Okay?
Not going to lie, Minister. The other room, it was too much of a love-in, and I felt like it was necessary to come here to be finally put back into my place. So I'm good to see you as well, and greetings to your officials as well, and thank you for being here. Can I ask, Minister, have you collected the money Uber owes us in back payroll taxes?
I'll pass to Mr. Johnson.
No, not as yet.
Where are we up to in terms of that litigation, Minister?
It's currently before the courts.
So we were in a period where I think it was identified last time that there were alternative dispute resolution, that there was negotiations or conversations happening as to whether or not it was possible to reach a settlement point prior to the Supreme Court having to make a decision. Has those conversations not reached fruition, Minister?
Well, you'll appreciate that I don't get involved in matters which are before a court, but to the extent that you want an update about why those proceedings are up to.
Exactly where we're up to with discussions, I'd need to take on notice. I'll be able to come back.
When's it set for hearing?
I believe a mention is later this year.
But when's it going to trial?
I'll take that on notice.
So it's been in litigation for more than a year, correct? You lodged a statement of claim last year, didn't you?
That's correct.
Early last year.
Last year, yes.
So what, is there some hold up at the Supreme Court, or have you been, what's going on? 2 years to a court hearing isn't usual, so what's happening?
There's nothing I can add to the comments I've just made.
Well, it's an $81 million suit. It's the biggest enforcement action I think from Revenue New South Wales has done. And I've got to say, I've previously been critical of whether or not we have been taking the action we should be to make sure that we are. So it's appreciated the fact, but this is a big item of compliance and enforcement. I would expect the Chief Commissioner, the Minister and or the Commissioner to at least know, why is it taking 2 years for us to be getting to a court hearing?
Well, I think you have an answer. I think we will come back to you in writing with an update in relation to it. I don't think there should be any criticism of the court process. If it does take time to, one can't sit here and speak for what response Uber makes and what how the proceedings are drawn out, and there might be a perfectly rational explanation. So what I'll be saying to you, Mr. Mookie, is allow the officials to give you a written update in relation to it. I agree with you. It is a significant amount of money to be collecting, and when we do collect it, I'll be the first out on the doorstep wanting to say how great the officials from Revenue are for pursuing a debt which is owed to the state.
Just see how far we go down that pathway.
Indeed.
Before you call that press conference. But can I
don't call press conferences like you do, Mr. Mookie.
I do appreciate the update that will be forthcoming from officials. But if it is possible, perhaps, for us to see what information might be available for this afternoon, that would be appreciated too.
We'll do our best to come back with some.
Have we made similar claims? Have we lodged any other statements of claims in relation to companies that are from the gig economy?
Not that I've been advised, but there might be.
So in the past, since we were last here, where we advised we'd completed 16 investigations in relation to the gig economy, we've completed three further.
completed 3 investigations?
Three further investigations.
And has that led to the lodgement of a reissuing of a tax assessment notice?
I would have to take on notice where the status of those are, but my expectation is the answer is yes, that we've issued a...
We've reissued assessment notices? And has any of those assessment notices prompted a challenge in a court?
Not that I'm aware at the moment. So as you know, Mr. Mookie, the way that these processes normally work is after an investigation, if a new or an amended notice of assessment is issued, there's then a period of time for the recipient to object.
Well, 90 days, is it?
Around that, but we do give leeway. So this is to object internally.
Yeah, I know. Yeah.
And then once that is considered, that may take a little bit of time. May involve, the toing and froing and provision of additional arguments, potentially.
Yep, aware of that.
Then a determination is made, and then there's a 60-day period for the recipient, the taxpayer.
So basically, according to that timetable, Commissioner, you would have had to have issued the updated notice of assessment earlier this year. Fair?
Yes. So I'll confirm when where those 3 further.
So I'm not going to ask you to reveal the additional assessment, but I am going to ask you to identify the 3 people who had, and bear in mind we've gone through this multiple times, in multiple forums, as to what you can say and can't say, and various practices have been established between us, I'm sure. But so I will just ask you now, can you identify the 3 companies that had additional notices of assessments put on them?
I'll have to take that on notice, Mr. Mookie.
Thank you, no problems. If it's possible we can get some information this afternoon, that would be helpful as well, if it is possible. I just want to move to another matter that arises from the gig economy minister, if that's okay. I understand that Ikea has made a payment to the family of a rider who tragically was killed on our roads last year. I want to acknowledge Ikea for that. I'm sure they would have followed the law, but that was a matter which was raised in these forums previously, and I've met with the family myself. I was hoping if we could just get an update on that particular matter about that family from Hungry Panda.
Again, you wouldn't expect me to give you
No, I'm asking Mr. CEO.
Mr. Harding.
Yeah, I wouldn't expect you, Minister.
Yeah, thank you.
Mr. Mookie, I'm not sure if you're referring to the settlement that occurred through the processes with the PIC.
I am.
Okay, so that was a settlement between Uber and the company, Uber and the individual.
No, I'm talking about the Hungry Panda matter.
Hungry Panda. Let me come back to you. I don't have the details of the individual case with
Do you mind taking it on notice?
I can certainly take it on notice. Yes.
Thank you. Yeah. But it is the case right now that there's a separate dispute that's taking place in the PIC after Ikea, look, to be fair to Ikea, applied the law in the manner in which they confirmed the opinion that they perhaps had given to us at a separate hearing in respect to the death of the Uber rider as well. The Freddie family is the incident that I'm specifically referring to. It is the case, is it not, that Ikea did reject that claim for compensation on the basis that the person wasn't an employee?
So, Mr. Mookie, I think I'm not sure exactly where you're going. Again, specific relation to the case that you're talking about, I'll have to come back to you. In general, though, it is a case-by-case assessment. It is, as has been the case all along, based on the contractual relationship between the individual and the company. And the case that we just talked about, Hungry Panda, where there was a settlement, wasn't a process where the PIC made a decision. That was a decision of the company involved to make a settlement. So the different outcomes based on case-by-case assessment of the relationship between, in this case, the riders and their contracting entities.
So, Mr. Harding, we might pick that up a bit later today as well. But, Minister, is Ikea doing a superb job?
Well, how long's a piece of string? But all my interactions with Ikea and the Ikea board, and I have to say the Ikea board is very well run by John Robertson, and he, I think, provides me with updates in relation to Ikea. All my interactions with Mr Harding have all been very professional, and notwithstanding that they face a very difficult environment in which they work in terms of the expectations of on them as an organisation, I have to say that I have the utmost confidence in them as an organisation. I've been given no reason to believe that we should have no confidence in them as an organisation.
So your view is that they are doing a superb job?
I beg your pardon?
They're doing a superb job.
I've got no reason to believe that they are, how you want to describe it as a superb job, but I think in my capacity as a minister I would have to form a view as to the level of confidence that I have in them and the level of support and the manner in which they report to me. There are some indicators that I would look at. To what extent has the culture of the organisation changed? You will no doubt potentially raise with me issues in respect of the return to work rates and the like. I am satisfied that the people who are running this organisation are the best people that we could get for this job, and they have my support.
Okay, thank you. Can we get, please, what was the net result of the nominal insurer in the last financial year?
You got the exact figure?
Yes, absolutely. You mean the year ended 30 June 2022, Mr Mookie?
I do.
Yes. The net result was a loss of $993 million. Would you like me to give you the details?
Oh, we'll get to that. Don't mind, Mr Harding, we certainly will. So, can you just give me that figure again, please?
It's a negative net result of $993 million.
So, last year, Minister, the nominal insurer's net result was positive 63.3 million, wasn't it?
Is that correct? You're quoting the figure. I've got no reason to believe that it's not true.
So in the last 12 months, Ikea's position in the nominal insurer has reversed by the tune of more than $1 billion. Is my maths accurate there?
Well, would you like me to give you the details, Mr Mookie?
I do, Mr Harding. We'll happily give you ample time to give us the details, but I'm just asking the Minister here, when were you advised that in the past 12 months, Ikea's position with respect to the nominal insurer had reversed by more than $1 billion?
Well, Mr Mookie, you would be aware of the pressures on every insurer in the insurance industry. The nominal insurer is not just insuring workers' compensation, it insures, it acts as the insurer for the HBCF, it acts as the insurer for lifetime care.
Minister, the nominal insurer doesn't act as a HBCF, nor does it act as a TMF, nor does it act as a sports injury fund. The nominal insurer only does workers' compensation. You are aware of that, aren't you?
Yes.
So, I'll go back to my question.
And you would be aware of the additional pressures on the Workers' Compensation Fund over the last 12 months.
Oh, look, I've been aware of the pressures that the Workers' Compensation Fund has been under for a number of years, but I'm asking you a very specific question. When were you advised that the agency that you have expressed utmost confidence in has lost, had a turnaround of negative $1 billion? Do you recall when you were briefed?
There is a loss of that amount.
When were you briefed?
I'm briefed every fortnight by Ikea. It would have been included in briefing materials that, I don't know.
So it comes as no surprise.
Perhaps if I jump in.
I think it's important that Mr Harding does give yes.
And look, Minister, we will have ample time. There's no shortage of time here, but I'm concentrating on your role.
Mr Mookie, you have asked a question. I'm entitled to answer it, and in giving that answer, I will have deference to Mr Harding, who will give context to the answer.
Well,
Mr Harding.
No, I'm not interested in context. I'm happy to hear from Mr. Harding. I'm happy to hear from Mr. Yeah, I'm very happy to go to Mr. Harding. I wanted then to be clear here, Minister. The question that I asked you, which I would love to hear Mr. Harding's answer to. If Mr Harding has this information because you don't have it, I'll happily
He
hear from
needs
him.
to give the context to it, Mr.
The
Mookie.
question is, how often have you been briefed? Now, Mr Harding, if he wants to say how often you have been briefing the Minister, I'd love to hear it.
Thank you. As the Minister has said, we speak with the Minister on a fortnightly basis, and each month, when the monthly rolls round in the fortnightly, the Minister receives the information about the financial condition of the fund.
Thank you, Mr
You will
Harding.
appreciate, Mr Mookie, that in this current environment, with interest rate movements, with investment market movements, it has been a very, very volatile period.
But Minister,
over $892 million has been a result of investment losses over the year.
No, I think it's important that he finishes this answer, Mr Mookie.
Mr Harding,
Over $1 billion has been a result
I'm
of the
almost
movement
tempted to take a point of
interest
order.
rates and inflation.
Can I, if you want?
I will
Wage
take a point of
inflation.
order.
Yep, Mr Nookie.
Sorry, but this is a time for which we can question the Minister. I have no doubt Mr Harding will be in a position to provide the relevant information this afternoon when we'll be returning to many of these subject matters. But this is the opportunity to question the Minister.
To the point of order, Chair.
Yes.
The Minister can choose to answer the question any way he wishes, including to deferring to officials.
Okay, so my ruling on this is there's two parts to this. The Minister actually has to be directly relevant to the question that has been asked. You are entitled to engage your officials here to assist with the answer, but you do have to be directly relevant. The question was very specific about dates and times, well, not dates and times, but when you're briefed. You've provided that answer. We've heard the confirmation from Mr Harding. The further information is straying from the question. So that's, I think, Mr Mookie's point.
Well, it isn't.
Well, it is.
With due respect.
It is. And so I will uphold the point of order. That doesn't mean you can't defer to your officials, but you do have to be directly relevant. And so does Mr Harding.
Minister, I do appreciate, and look, I just want to acknowledge there's no implication that I'm suggesting that Ikea has withheld information, and I do want to acknowledge the fact that Ikea has been regularly reporting to you on this matter. So, given that you've been receiving regular reports about this $1 billion reversal in the position of the nominal insurer, what steps have you taken and directions you've given Ikea to ensure that this pattern of $1 billion losses doesn't continue?
Well, there are a number of levers that can exist in relation to stemming losses. There can be an improvement in investment returns, as Mr Harding started to tell you, but you didn't want to hear.
Is that what you directed him to do?
You can let me answer?
Sure.
Thank you. So there is an improvement in investment returns. There can be an improvement in the manner in which claims are being managed. There can be an improvement in operational expenses, and then can be increases in premiums. So they're the sort of levers that you would expect an organisation to avail itself of in respect of trying to improve its position. But, you know, there are other things at play here, including inflation and the like, which do impact on the insurer. But, you know, there are a variety of levers which it is able to pull to try and reverse that position.
It would be impolite of me not to ask, what is the funding ratio of the nominal insurer now and the insurance ratio?
The insurance ratio of the NI is 102% and the accounting ratio is 94%. So,
Minister, this time last year, at the end of the previous financial year, the insurance ratio was 122%.
Right.
And the funding ratio was 99%. So the insurance ratio has dropped by an astonishing 20% in 1 year. And the insurance ratio, the funding ratio has gone down by 4. In light of that alarming deterioration, do you stand by your comments that you have utmost confidence in the way Ikea is doing its job?
yes.
Fair enough. Can you tell me, in respect to the only other figure which I wanted to get this morning, and we can come back this afternoon, is are you in a position to tell me what the underwriting loss was for the nominal insurer?
For the
underwriting loss for the nominal insurer last financial year.
well, tell me what you mean by an underwriting loss.
Add a definition, Minister.
No, you tell me what you mean by it. Does it include investment returns?
No, that's not. But Minister, you just to be clear here, Ikea has always reported its underwriting positions and its net positions, and I accept the legitimacy of your point, which is investment returns are there.
Well, because what you're going to do is you're going to misconstrue an underwriting loss without taking into account investment.
Well, why don't we do the following? You tell me what the underwriting loss was, and then you can give me the explanation you wish to give. So what is the underwriting loss?
Well, I think there was six.
Very happy to tell you, Mr. Mookie, the underwriting result for the nominal insurer was $101 million loss.
$101 million loss. Thank you.
Which reflects the point we were making before about the volatility of external factors.
Sure. Is there anything you'd like to add to that? Fair enough. Can I ask you, in respect to Ikea and its remuneration practices, have you instructed Ikea not to pay any bonuses this year?
I've given no instruction. The individuals who work for Ikea have contracts with Ikea. I expect the Ikea board, which is capably led to, in fact, take into account the contracts which it has entered into with its employees and provide me with a briefing in terms of...
is Ikea going to be paying bonuses this year?
It's a matter which is still under discussion.
Do you have any objections to them paying any bonuses?
What I would say in relation to that is my principal position is that Ikea ought be employing the best possible workforce that it can to serve the workers of this state. And I would take you to this, Mr. Mookie, is this. Ikea works in a very important commercial environment where the people who work in the insurance industry are highly prized and highly sought after. And Mr. McDougall, in his report, had this to say in consideration of the remuneration for Ikea. No, just let me finish, please.
If you don't mind just answering the question, that would make things a little
I will come to it. I'm still answering a question about remuneration. When Mr. McDougall said this, when one considers the size and purpose of Ikea and its responsibilities, Ikea's executive remuneration packages sit appropriately within the range of other public and private sector organisations. So that's the primary position. It was established by Mr. McDougall that is the current position with the executives who work in this organisation. By and large, I have already said to you, I value those executives, and in the circumstances, I think that they ought to be paid appropriately. The question of bonuses this year and alteration to remuneration packages is still under discussion, and I expect a brief in relation to that to be provided to me shortly.
So you have no objections to Ikea's board choosing to pay bonuses if they think that's necessary?
Well, if the board reaches a decision and makes a recommendation that they pay, that will then be a discussion between the chair of the board, John Robertson, and I.
Well, can I just ask, does losing $1 billion in the nominal insurer and requiring a $1.9 billion injection of funds in the TMF justify the payment of bonuses in your view?
I beg your pardon?
Does losing nearly $1 billion in the nominal insurer and seeking a $1.9 billion injections of funds into the Treasury Managed Fund justify a claim for bonuses?
Well, I'm sure that they are circumstances which are considered by the board for the purposes of making a decision in relation to bonuses. But let's just identify the $1.9 billion which you've identified. Is that the figure that you identified for the TMF?
That's what the Treasurer told us was required as an injection. And my question actually I was going to ask you about this, Minister, was I'm glad we can talk about this, because I was going to actually ask you, given the Treasurer told us on Monday that he was required to execute a further $1.9 billion of injections of funds into the TMF, and that follows Treasurer Perette's decision to inject $2 billion in 2020, meaning that in the past 3 years, we've had to inject nearly $4 billion into the Treasury Managed Fund. Did Treasurer Keane tell you he was about to inject $1.9 billion into the TMF?
He would have made that decision on around the time of the budget. But what I say to you is this.
Did you concur with Ikea's request for a bailout?
What I say to you is this. The problem that you have in understanding the TMF And I think, quite frankly, you have misrepresented this for a long period of time.
Tell me.
For your political purposes.
Please, let me know. How have I done that?
You do not understand that the TMF is a self-insurer. Now, if there are facts and circumstances where a self-insurer needs to pay claims, and they are not covered by agency levies, which fund the TMF, then in those circumstances, consolidated revenue is required to fund the TMF for the purposes of meeting the claims. Now, you'd be aware, and I hope you are aware, some of your public pronouncements do not indicate that you are aware, but that we do have had a significant amount of flood activity. You would be, and they involve the repatriation of public buildings. You would be aware that there are roads which have been significantly destroyed by flood. Now, all those events impact self-insurers. Now, we can elect not to fix the road, in which you would say, why aren't you fixing the roads? Well, if it's the result of a flood, or if a hospital needs repatriating because of a flood event, or a school needs repatriating because of a flood event, or a fire event, or some other event, then in those circumstances, a self-insurer needs to, in fact, provide the funds to actually do that work.
Well,
so,
Minister, I do acknowledge...
What I just would say to you, Mr. Mookie, is do not characterise the $1.9 billion as anything exceptional, other than to say we are meeting our insurance obligations as a self-insurer.
No doubt, Minister, and I do agree.
And I just make this point. Mr. McDougall, in respect of the exactly the same point that you continue to make, says this: the allegation of a $4 billion bailout was factually incorrect to the extent that the media commentary, often supported by you, sought to assign to Ikea responsibility for the need to transfer of cash into the TMF. It was wrong. The losses in the TMF were not attributable to Ikea's mismanagement. So if you want to ask...
Minister, just bear in mind, the McDougall made his finding a good year before the $2 billion injection. So I don't think you should...
But do you accept the premise that I put to you, Mr. Mookie, that this is a self-insurer relying on its own funds?
Minister,
to meet
I'm
its
prepared to acknowledge the profound insight you have that insurers are required to pay claims. That is true.
But it's an insight that you seem to ignore.
True.
Issue that you consistently ignore.
But the issue you have is that Treasury told us that the flood costs of the TMF were circa $200 to $300 million paid out from there. So of the one, when they gave us...
You asserting mismanagement?
Yes, actually, to be clear.
To be clear, then,
just, Minister, let me ask the question, because I enjoyed you getting very confident in your point there. But just to be clear here, when we asked Treasury for what were the reasons for the bailout, they actually did itemise it. And the flood factor, no doubt, it's important, but it's not the whole cost. And the extent to which you continue to hide behind flood and flood-related events to disguise the deterioration...
Well, no,
let me just finish. It doesn't bode well for you either. And I know this because I'm looking at the budget, and every single agency, every single one of them, is having to pay more in workers' comp premiums to Ikea.
Correct.
To account for the fact that the TMF's performance is deteriorating.
No.
So that was a nice 7-minute exchange you and I had.
Well, no,
but let's just get to the actual...
I'll go through some of the other factors.
No, let's just actually get...
You've raised flood. I'll go through some of the other factors.
No, because the question...
Okay, can we just take a pause? We need one person at a time. We have to keep a transcript. We'll have a question followed by the answer.
I will ask the
both of you.
I will ask the question.
He has, in fact, asked me about those things which impact in relation to the $1.9 billion. So let's go through them.
Well, let's not guess. Sorry, Minister. No, Minister, sorry. The question, Mr. Mookie will ask the question that he chooses. There's no point trying to guess what the question is going to be.
He should not interrupt my answer.
Well, perhaps you should both stop interrupting each other so that we can have an orderly proceeding.
In that case, Chair, I'll finish my answer.
Well, actually, I hadn't actually asked the question.
I'm not sure they actually asked a question.
You don't want to know.
I will take a point of order.
You don't want to know.
I will take a point of order.
Yes, Mr. Mookie.
The Leader of the Government knows full well that I should be allowed to ask the question, and then he can go and tell me how the question is wrong, which is what I usually do in this forum. So let me at least just go back to the question, if that's okay, Chair.
I'll
Don't misrepresent.
uphold the point of order.
Don't misrepresent.
Let's have the question, then you can give the answer however you like, as long as it's strictly relevant.
Don't misrepresent it.
The only real question that, before we went on that 7-minute exercise, was this: when did Minister to Treasurer Keane tell you?
There was a question in between that.
And now the question is this.
No, well, let me finish answering the first one.
Oh, you did finish.
No, you don't want me to answer the first one.
Look, I will take another point away. Literally, the Minister just interrupted me again. Rather than him, can you just allow me to ask the question?
We need to hear the question, followed by the answer. I'll let you answer the question, and if he cuts you off, I will deal with that. But let's hear the question.
To the point of order, Mr. I don't know if I can take that.
You can't, sorry, Minister.
To the point of order, as prompted by the Minister, I think that it is unhelpful that the Honourable Daniel Mookie interjects midway through the Minister answering the question. And I think that this should be a question-answer format, and the Minister should have an opportunity to answer each question that the Honourable Daniel Mookie presents to him. And I'm particularly interested in the question about the other drivers behind the claims costs rather than just floods. And I think that it would be good to get an answer
we're straying
from the Minister on that particular question.
Sorry, but I will call both of them to stop interrupting each other. This is not the Minister, Mr. Mookie interrupting the Minister, it's both of them. I have repeatedly asked both of them to stop. We'll have the question followed by the answer, etc.
You've got to both put into the naughty corner here, I've got to say, Minister. The simple question, did you sign off on the request for an additional injection of funds or not?
No.
Thank you. Let's talk about the premiums.
Well, can I finish my answer to your earlier questions about those things which impact on the $1.9 billion?
So you gave me an extensive answer to that question.
No, I haven't finished
and I really valued your information that you gave.
Would you like to? I'd like to complete my answer in relation.
Again, Minister, you are again threatening to have us both sent for a second time into the naughty corner.
Well, but I'm entitled to answer the question in fullness as to those things which impact. And you in fact said it's quite fairly, Mr. Minister, it's not only floods, and I agree with you, and that's why it is important that I spell out the other impacts on the fund which lead to.
Minister, let him answer.
Just to be clear, I've never thought I'd ever had to say this, but you'd find that David Elliott seems to have a better understanding of estimates procedure than you are rinsing right now. So perhaps if you can just let me get back to my question.
That's a bit unfair.
Minister, I appreciated the fact that you did issue a direction which capped the premium increase that took place for the coming financial year. And to be clear, I think that the 3.2 million businesses that have to pay premiums to Ikea appreciated that too. But it is a fact now, isn't it not, that given the nominal insurer has lost another $1 billion, that's going to mean 3.2 million businesses will be facing year after year after year of premium increase. Isn't that true?
Well, and you will then appreciate the difficulty of making that decision in the circumstances where businesses were seeking to recover from a pandemic when they were potentially facing circumstances where they needed to be able to reopen their doors, pay back increasing amounts of rent, catch up on mortgage repayments and the like. And I have to say, and I think you have indicated you agree with potentially the position that I took. And next year, a further application will be made, I am sure, by Ikea for premium increases. What I would hope is that the economy is in such a state that businesses are able to cope with the level of premium increase which will need to be passed on. But Mr. Mookie, it's never easy to make a decision in relation to a premium increase in circumstances where we were faced with very fraught circumstances coming out of the pandemic.
Minister, and I understand and do appreciate the fact that it's never a good time for a premium increase, but you do understand right now it's an especially bad time because businesses are dealing with worst inflation crisis in 3 decades caused by multiple factors. Rising interest rates, which is increasing the cost of capital.
Yep.
But at the same time, 3.2 million businesses in New South Wales will be facing premium increases that will have to run at least into the middle of next decade just to compensate for the last 4 years of poor performance by Ikea in its management of the nominal insurer.
Well, that part of your assertion I disagree with. I do not necessarily agree with. That is, you are able to, in fact, make that speculation. So what I'm saying is this: in relation to that, what I would say is that given the assertion which you have made, there are other things that Ikea can do to make sure that it tries to keep premiums under control. Claims management performance would be one way that we can drive down potentially premiums. In fact, if we got better outcomes in respect of workers returning to work, there are operational efficiencies that Ikea can make which will potentially drive down premiums. So all you are engaging in at the moment is speculation, which is driven by your inherent pessimism and pursuit of a headline. But fine, but give credit to Ikea that they are also in the business of making sure that they try and keep premiums down for businesses as well. And they are, in fact, charged with, in many respects, doing things internally, which will, in fact, relieve the opportunity. So
you're maintaining the position
I understand that you're pursuing your headline that you want to get out that businesses are facing premiums increases. Well, the fact of the matter is that a responsible approach to that would be to say that we have such a good organisation that they are inherently cognizant of the fact that there are levers that they can pull for the purposes of making sure that we reduce the pressure on those
Minister,
premiums.
I just want to give you a clear opportunity to accuse me of this. Just be clear, are you accusing me of making up the assumption that premiums are going to need to rise for the next decade? I want you to be very clear about the accusation you wish to make about me.
I'm accusing you of this, of saying that is speculation on your part. And what I am saying is that an organisation, a commercial organisation like Ikea, has lots of levers available to it to try and make sure that it's driving premiums.
So just to be clear, you're accusing me of speculating about future premium increases, are you?
Well, of course, next year I might be faced with similar circumstances, and who knows what direction I will give in relation to premiums.
Well, let me just then, I appreciate the clarity of your accusation, Minister, here. But let me then now just read.
Well, no. The clarity which I'm trying to afford to you, Mr. Mookie, is to identify and acknowledge that Ikea is well run and that it is focused.
I'm not going to acknowledge that Ikea is well run.
Claims management. It is focused on change culture. It is focused on operational outcomes, and you should focus on the quality of the board of management led by John Robertson.
I'm very happy to deny any accusation that I've made that Ikea is well run. But let me just put to you, because you've accused me of speculating about future premium increases, and I don't want to be fair to you, Minister, about this too. But I'm just going to read to you from the nominal insurer's financial conditions report that was presented to the Ikea board last year. It says this: a series of increases in premium collection rates are achieved, with 1.52% of wages to be collected in FY 22-23, and then annual increase of 2.9% for 5 years, achieve 1.75 to 2028, followed by more gradual increases in the next 4 years to achieve 1.88 by 2031-32. So, it's not my speculation here, it's the report that's going to your organisation's board. Your organisation's board has been told that in order to rectify the losses that were incurred until last year, which to be clear doesn't include the $1 billion that's been lost since, that premiums that will be paid by 3.2 million businesses will have to rise by more than 33% by 2031-32. So, it's not speculation, it's what your board has been told. Your board has been advised that the 3.2 million businesses that pay into the nominal insurers fund will be facing premium increases of 33% by the end of the decade. Do you want to take this opportunity to apologise for them for the mismanagement that's taken place under your government's watch?
And I again say to you, Mr. Mookie, it behoves the Labor Party to stop talking down the good public servants of this state who do an excellent job in looking after the commercial organisations which provide services to the workers of New South Wales.
Well, Minister, I got to put you up there.
What you would be better doing, is instead of talking down our public service agencies, engage in, if you did it just by 10%, stop doing that by 10% and concentrate on some policy work, guess what? You'd probably contribute a lot better to public discourse, because that's the way the public discourse
I'm going to have to pull
improves.
you up there, just in case you haven't realised. IKEA aren't public servants. You may have missed that. I've got a bill in Parliament that would change it, and you're welcome to support that.
In fact, I certainly won't support that.
I'm not shocked. But you can understand how terrible those 3.2 million...
Public organisations, though.
There's 328,000 employers in the
Insurer. 3.2 million
not
workers.
3.2 million.
Sorry, I do apologise, Mr.
So you didn't get that?
I appreciate the correction. The 328,000 businesses that that cover 3.2 million workers would be pretty outraged that they're facing at least a 2.9% premium increase this year and premium increases running for the next decade. At the same time that IKEA's performance is once more, its return to work rates are again falling back.
And why is that, Mr. Boogie? Why is that?
Well, I'd hope you know.
Well, do you know?
I have a theory, but let's just get to my question.
Do you know?
Minister, let me just get to my question.
Because you didn't allow me to answer the question previously.
Do you accept that those 328,000 businesses would be outraged at even the mere hint of a suggestion that the additional premiums that they're going to have to pay in the worst inflation crisis in the 3 decades would go to bonuses to the executives that have been responsible for presiding over a disaster?
Well, I would expect that all those businesses would be grateful for the fact that I have pegged the premium increases at a time when they were significantly under pressure, when they were emerging from a pandemic. And what I would say to you is that the premiums will be revisited next year in the light of what circumstances exist at that time, and that's the appropriate time to be asking that question. And what I would further say to you is any forecast which is a 10-year forecast is absolutely speculative, and there are many unknowns which may exist, and some of the ones I've already potentially pointed out to you. So there are 2 parts to your question. Am I outraged that our premiums are going towards making sure that we have a very skilled workforce? The board will make a decision in terms of the remuneration package which it represents. I have every confidence in the decision-making power of that board, and it is run well by John Robertson. And I'm sure, and in fact, it surprises me that you never called him to be a witness in these proceedings, because some of the allegations you want to make against the IKEA, I would like you to make those same allegations against him as the chair of a board which is responsible for overseeing the decisions of this organisation. But you never do. You never do. And it surprises me that you never asked John Robertson to participate in these proceedings and ask him whether he supports a remuneration increase.
Minister, we might take you up on that offer.
You haven't in all the times that I have been to these estimates, and he has been the chair of the board. You never ever seek to call him and ask him the same questions as you want to ask in relation to the performance of IKEA. I just wonder why that's the case.
So you're happy?
Why is that the case?
You're happy for Mr. Robertson to come to the supplementary hearing?
I would be happy for Mr. Robertson to come at any time to answer, but it is open to you to call Mr. Robertson and ask him the question about whether he supports the remuneration packages which he wants to.
Minister, I do seek your forgiveness for having the temerity to be asking the minister the questions, but nevertheless, let me just.
But it's curious, don't you think? It is curious.
Well, I would have thought that the person who perhaps should be responsible, I don't know, is the minister of the government. Well, but no. Look, to be fair, I grant you this. Your government does have unusual arrangements that are in place for who answers what questions. I have no doubt doubt that I do confess to struggling to keep up with who's responsible for what in your government. But to be fair, I think your government struggles even harder.
Mr. Mookie, the gratuitous exchanges we can avoid, okay? If you want to engage in rhetoric and all that sort of stuff, that's a matter for you. But
clearly, I'm the only one who does. I'm the only one who does in this hearing.
Yeah, well,
can I just say?
Just ask me the question and
I'd like to, if you actually let me answer the question.
Well, just don't engage in the rhetoric which goes around it.
Okay, let me ask you this one then.
Yeah, okay, good. Let's give us that one. Next one.
I am worried by continued reports that Ikea is still, for good reasons and for perhaps not some not good reasons, underpaying injured workers when it comes to calculating their PRE. What briefings have you received about whether or not Ikea is continuing to underpay and, to be clear, overpay workers when it comes to calculating their pre-injury average weekly earnings?
I get regular reports, and in fact, to make sure that you get accurate information, I will ask Mr. Harding to give you that update.
Please.
Mr. Mookie, at the moment, we are in the process of finalising the remediation of the PRE miscalculation errors.
Not so much the remediation, it's the calculation of PRE for current claimants. In that we've had, where are we up to in terms of figuring out how many of them are still being prone to underpayments or overpayments?
So the process of improving the calculation of PRE, as we've talked about before, PRE is quite a complex process. What we have instigated is a process of quality assurance around that, continual training and development of the CSP staff who are accountable for it, and we continue to drive that as a continuous improvement effort. We've worked with Insurer on a simplification of the approach to that so that we can ensure that injured people do get paid accurately at the point in time that they make their claim. And then when new information does come to hand, that the claim can then be adjusted and the information applied to that. It is a matter of continuous improvement, Mr. Mookie. It is a matter of us running quality assurance processes, as all good businesses do, looking at the results of those, working with the CSPs to drive further improvement and to continue to make that improvement across the board. It is not a simple answer of solve it. We have reinstigated new premium wage calculators to help support the CSPs in that process, and it is ongoing. It is not in fact, I don't think it'll ever end, Mr. Mookie, because it is, by its nature, a complex process, and by its nature, it's a process where we do need to keep that high visibility on the QA process and high visibility on how we ensure that we continually improve it.
And look, Mr. Harding, and to the Minister, I do want to acknowledge that certainly in respects to comes to PRE, Insurer has questions to answer to about their role as a regulator in clarifying precisely what insurers have to respond to.
Well, we found Trib very helpful in clarifying and providing us with guidance, and we now apply that guidance.
I'll just remind you, Mr.
Mookie, that at any time, anyone who feels they've been underpaid can request a review, and that's an ongoing process as well.
Mr. Harding, I appreciate that, and trust me, we will pick it up again this afternoon, but I just do want to ask a question to the Minister. Minister, it was a welcome initiative when your government decided, after some advocacy on behalf of many injured workers as well, to issue a blanket repayment to collectively worth $38 million to the 53,000 injured workers who were underpaid between 2012 and 2019. And I just want to place on my record that finally that was a good decision to go down that pathway as well. But can we get an update from you, Minister, as to how many of the 53,000 injured workers who were entitled to a payout have actually received it?
Mr. Mookie, as at the 1st of August, there's two components to the remediation program, as I started earlier. We have reviewed over 24,322 eligible claims, of which 1,238 payments have been made, and they total $6.5 million. 21,000 workers have been offered the proactive payment to date. 10,782 workers have taken that up, totalling about $7.4 million. We're actually very happy with that take-up rate. The advice we received from Deloitte, the wage remediation experts that we've had engaged to support us with this process, would suggest in other wage remediation programs such as this, take-up rates as low as 25%, and we're seeing it around about 50%. Unfortunately, the remaining number of workers, the process we've been working through with the Department of Customer Service and Service New South Wales to make those final payments has been delayed. It's been delayed as the government prioritised COVID-19 relief payments and flood relief grants. So we are working with Service New South Wales to get the final injured workers contacted and payments made by the end of the year.
Appreciate the update, Mr. Harding. Minister, were you advised that a decision had been made? Well, firstly, this was a policy that was announced around the 11th of November 2021, correct?
Yep.
When were you advised that the government had decided to delay the repayments to these injured workers?
I couldn't give you the exact date, but I was advised, and in fact, I was aware of the delay because of...
Who made the decision?
Well, it's a resourcing decision. Because the decision to actually use the resources of Service New South Wales involved them in having to make sure that they had the appropriate resources to be able to make those payments. So,
then who actually made the request? Did they ask you, or did you ask them, or what?
No, we were informed by the Department of Customer Service that they needed to delay the work that we were doing with them to enable the government to address these other priorities. So it's purely in the hands of...
made the call.
Purely in the hands of Service New South Wales.
It's a resourcing issue.
Well, but I'm asking you, Minister, did you have discussions with Minister Dominello about this or not?
No.
So what, this was a decision made by Service New South Wales?
It's an administrative decision that they had. They have so many resources available, and I think even you would agree. I don't know if you would, but you probably would agree that looking after flood victims, getting COVID payments out, getting businesses with payments did in fact create some headwinds for the personnel at Service New South Wales and resourcing the grants and payments that needed to be got out the door.
I don't dispute
I wasn't surprised by the advice, and I could understand it in the context of the resources which were available.
Look, and no one would dispute the fact that at certain parts of this year, last year, the year before, Service New South Wales has been under immense administrative pressure. That's clear. But it is the case that leaves 32,000 injured workers are not yet contacted and told that they might be entitled. Just let me finish. Now, to be clear here, it was... these workers were underpaid from 2012 onwards.
Sorry?
These workers have been underpaid. Some of these workers have been underpaid from 2012 onwards. The bulk of the underpayments, according to Ikea's previous evidence and various inquiries, took place between 2012 and 2015. Now, that means that these workers have waited nearly a decade. Some of them have waited a decade for this. Now, I accept that there's administrative pressures, but what are your expectations as to when Ikea will complete this? What parameters have they got to come? What are your expectations as Minister for when these workers will get the money that they're owed?
Just the advice that was provided to me was that in May of this year, Service New South Wales went live in contacting approximately 23,000 workers with a campaign, which is now complete. The remaining 20,000 workers are awaiting the Privacy Commissioner's approval to utilise Service New South Wales data set to email those workers. Is that correct, Mr Harding?
Yep.
So the campaign began in May?
Well, there was a campaign in May about contacting workers.
Well, did it stop because of administrative pressures, or did it stop because of the Privacy Commissioner?
Two different issues.
Well, I appreciate that, Mr Harding. So both issues have stopped it?
The work on the Privacy Commissioner relies on Service New South Wales, and Service New South Wales had to prioritise the work on the other two relief payments, which would have similar issues in contacting people and using the Privacy Commissioner. So they're interrelated.
Okay.
They're all one thing.
But the effort to contact workers only began in May. That's what you're saying, Minister.
Can I help, Mr Mookie?
According to the Minister, if the Minister says you can, you can.
You can help. Yeah. In fact...
you might need his help.
As you may be aware from our previous conversations, we actually wrote to people last year. And that is the reason that we have the original 24,322 reactive responses to people requesting a review. So every person has been notified of the opportunity, and they can request a review at any point in time. The campaign that started in May was the actual issue of mailing out and phone calls from Service New South Wales around the proactive payment.
Indeed, and I appreciate the context, Mr Harding, but part of the reason we went to the proactive payment policy, which is a good policy, was because the earlier efforts had not succeeded. So I'm just asking you in respect to the proactive policy component of this remediation effort. It was announced in November, but it didn't begin until May. Is that the facts, Minister?
Well, no, I think there was some work done in February.
Well, as you can imagine, Mr Mookie, arranging the data transfers to Service New South Wales, setting up the processes for the phone calls, the processes for the payments, negotiating with the Department of Social Security, negotiating with the Tax Office to ensure that when we do make payments, payments don't impact people for either of their Social Security benefits or their tax benefits, does take some time. Okay. And so between the announcement of the policy and the implementation in May, we did an enormous amount of work on all of those issues, including setting up Service New South Wales so they had a clear understanding of the process, the script, the rights of individuals, the processes for requesting reviews, etc. So it's not a simple, straightforward push a button and it happens.
I appreciate that, Mr Harding. Minister, then I'll return to my earlier question, which incidentally you haven't answered. When do you expect the proactive programs of repayment to complete?
It depends. I think,
as I said earlier, we are targeting December, but we are dependent on the Department of Customer Service.
Well, that's basically 3 months. Are you confident, Minister, that will be hit?
I'm not running the process.
Yes, but you're accountable for it. So are you? Well,
I'm confident that given that there are no other exigencies which get in the way of DCS actually delivering these payments, that that's an achievable target.
Okay. Can we talk about the repayment, the underpayment of people and estates that were underpaid collectively, apparently 93 million, who were the victims of dust diseases. Can you give us, Minister, what's your understanding of where we're up to in terms of remediating the people who have died from dust diseases and the people who are still living with dust diseases and money that was owed them?
My understanding is that it has been completed.
It's completed. I'm happy to give you the data, Mr Mookie.
Please, could you?
And just to clarify the number is 34.3 million. And we have contacted 1,179 participants and estates, and all payments have been made to those. There are 33 estates that remain uncontactable at this point, which you can imagine, I'm sure, going back, the beneficiaries and the executors of those estates over time disperse. We are in contact with 150 estates that we've contacted, but we are waiting information to enable the payment to happen. So that process is finalised to the extent, other than those small numbers, and payments have been made.
I do appreciate that update, Mr Harding, and to be very clear here, my understanding is that all these events which led to that underpayment took place well before your involvement with Ikea. But, Minister...
It took well before Ikea was formed.
Well, that's disputed. But
well, why is it disputed?
Well, because I'm about to dispute it for you, Minister, so let me do that. So let me just... but it's clear, your board, the Ikea board, was told about this in 2015. The report is there. They were told in 2015, and granted, I appreciate that was before you were the minister as well. It was then apparently re-highlighted.
Well, listen, let's not have the rhetoric. You've got your answer. It's been paid.
No.
Okay. Let's not have the storytelling. Okay. It's been paid.
Minister, your board was told in your board was told in 2015 about it. They were retold about it circa 2017 and 2018. Literally, the explanation that was then given when it was rediscovered was apparently nothing happened.
Mr. Mookie, if you're using this forum to tell a story...
Minister, I'm using this forum to ask a question, and it's an important one.
You're taking a long time to get to the question.
Lots of people here have been dealing with this organisation at the same time that they've been dealing with diseases like mesothelioma, Minister. So maybe you should just let me ask the question and you can respond however you see fit.
If you want to tell a 5-minute story before you ask the
Minister, many of the reasons why we are struggling to find these estates is because people died whilst this has all happened. Now, it's a relevant consideration. The fact that your organisation was told about this in 2015 and we've had multiple people who have died in the period since, it's an important question. The question is what steps have you taken to ascertain why Ikea never got around to remediating these people and their estates until it was re-brought, to Mr Harding's credit, back after he became CEO? That's the question, because part of the reason why we can't find these people...
I'm satisfied that Mr Harding has dealt with it.
No, what steps have you taken to ascertain why it is that Ikea was able to ignore this problem until Mr Harding's arrival?
I think that's an appropriate question for you to ask the chairman of the board.
No, I'm asking you as Minister, given you have the responsibility here. What steps have you taken as Minister to ascertain why it is that Ikea was allowed to ignore this problem until the arrival of Mr Harding and his new team?
Well, what steps I've taken is ensuring that we have the best competent and most competent people available to make sure that this is actually delivered. And I think you've acknowledged that Mr Harding has delivered that.
You've done nothing.
Mr Mookie, I have ensured that the payments have been made.
Minister, what is the consequence for the HBCF of Oracle's collapse?
Well, I think there have been 170 identified homes in New South Wales. My understanding is that Ikea has, in fact, or HBCF has, in fact, delivered application forms for those 170.
We're in the process of talking to them, yes.
I'm happy to hear an update from Mr Harding if he has one.
Yeah, okay, but I'm sure it is. I think that it is early days, Mr Mookie.
It is very early days,
and the assessment of the exposure of the HBCF to the Oracle collapses probably some way away from being ascertained. But Mr Harding can...
Well, what the Minister said is basically the answer. There's 179 current policies. Homeowners that we're in contact with to ensure they have the opportunity to make a claim. At this stage, we have a very early and preliminary estimate of around about $10 million. It's hard to say. That doesn't include a defect rate at this stage. So, as I said, it's 2 or 3 days a week since the collapse, and we're still working with the participants to identify it.
When was Oracle first provided with policy?
I don't have the original information. What I can tell you, Mr Mookie, is that we suspended Oracle from coverage in May this year.
All right, can you bring the microphone earlier, Mr Harding?
I don't have the information that you just asked for. I'm happy to get it. I imagine it goes back a number of years. We suspended their coverage in May this year.
Why did you suspend their coverage in May this year?
Well, they no longer met the criteria for eligibility to the fund.
In which respect?
Well, I think it's a little bit obvious now in respect to their financial condition and stability.
And they were...
I don't know that there's value in us reeking through an individual company's accounts here.
Well...
They've made statements in the media about their situation, and I think that's the relevant information.
I guess in terms of whether it's valuable or not is in the eyes of the beholder, really. But I'll just continue to ask the questions, if you don't mind. But prior to May, it is the case, is it not, that HBCF eligibility has to be checked? Is it every 12 months upon reapplication?
Yes, we do regular checks. Some are 6 months, some are 12 months, depending on the nature of the...
Okay. Was Oracle subjected to an earlier check 6 months prior to the May decision?
I'd have to find out for you, Mr Mookie.
Could you? Could you also identify whether or not any issues were flagged at that point? In either of those two checks?
I'll find out, yep.
Yeah. And can we also, just in terms of you said it was 10 million, did you not?
Approximately. I think it's a very early estimate, so I wouldn't be,
What is the current funding ratio of the HBCF?
As you are aware, Mr Mookie, the HBCF has two parts. The pre-2017 elements of the HBCF are underwritten by the New South Wales Treasury, and they effectively don't have a funding ratio, but the amount of funds that are in there is about 23%. In respect to the post-2018 to 2017 period, the funding ratio is 80%. The insurance ratio is 80%.
The insurance ratio is 80%, and what's the funding?
The accounting ratio is 78%.
78%. Well, that's a good improvement from what it was last year, and that's a result of basically repricing premiums, is it?
Well, as you know, there's been a consistent, since 2017, process of repricing premiums. We are now at a point where premiums are at a sustainable level. There's probably some risk-based assessments to be made around that, but at an overall level, it's at a sustainable level. So it's the first year that we've reached that. So over the next few years, the funding ratio will continue to improve, which is obviously what the policy and the strategy has been since 2017.
Indeed. But it is the case that liabilities still exceed assets by the tune of 22%.
Obviously, yes.
Yes. And at the same time, that's when the Oracle claim, which would rank as one of the larger claims that have been made in respect to in the last 12 months, 24 months?
It's of a similar size to the previous claims that have been made, yes.
In total?
In total.
Yeah. So in total, usually the HBCF ever says how many claims per year?
I don't have that data in front of me, Mr Mookie.
But 170-ish would be equal to. So it's a big claim. We accept that.
When I say equal to others such as Privium and other builders who've had challenges in the last 12 months.
Okay.
Yeah, a similar scale to those critical builders.
Yep.
I actually have the number, 648 claims we have in a year, in the last year.
So it's about 25% of the total claims per year if it were benchmarked to last year. That's fair. Okay. At this point, though, we're in contact with the home purchasers, and thank you. That is important for those people who are dealing with it.
Absolutely.
Just for us to clarify as well. Minister, I'm going to be sensitive about this one as well, given that this one is a slightly different one. And so I'm just going to give you the opportunity to provide us with an update, either you or Mr Harding, as to where we are in respect to the Metricon issue.
I'm happy to.
We gave you a very extensive briefing in relation to that.
A couple of months ago you did, and I did appreciate that, to be very clear. But it's a continuing issue that's even more perhaps given that we've had another claim, as we've just established with Oracle. And all I'm asking for is a further update at this point in time about where we are with the Metricon matter.
So, well, again, and I think the Minister's right in asking...
I think it is sensitive because we do
talking about a private company who's in the process of restructuring itself. They have made public announcements about their restructure. We have worked with them and their partners. We're comfortable where they are at this stage. We are monitoring them on a monthly basis and working with them. And they're making progress towards their restructured outcomes. So at this point, there is no change in the situation with Metricon. We've worked with them and they are addressing their restructuring issues.
Indeed. And what I am, in terms of what's been publicly identified information, it has been publicly identified that ICARE did impose a cap on the number of policies that could be issued to Metricon. Is that cap continuing?
Maybe if I speak clear, and I think this is quite difficult, Mr. Wood, because we're getting into commercially sensitive information for the
Well, it is difficult. I accept you, but this is a public accountability function that we have to discharge for a very important scheme.
Don't abuse it.
Well, I'm not, Minister. I'm referring to information that's already identified on the public domain, and I'm asking a really simple question, which is, has there been a change to that position?
What I can say to you, Mr. Wookie, is we have agreed a plan with Metricon that is part of their restructuring that includes changes to the number of new dwellings that they can take on. over time. But I really do not think it's appropriate for us to get into conversations about how many and when and where.
I didn't ask you how many, when, or where, Mr. Harding. I asked you whether or not the cap
Just
remains.
anticipating where you might like.
Well, please perhaps don't anticipate and instead try answering. The question was really straightforward. Has there been a change to the cap? I'm not even identifying what the cap was. I'm just asking you, has there been a change?
We have agreed a plan with Metricon that they are following and that is part of their overall restructuring with their partners.
Minister, what advice are you receiving currently about the state of the building industry, which is under well-known pressures, and the ability of the HBCF to survive the collapse of one or more major builders in New South Wales?
No, it's a really good question, and in fact I think it really is something that is worthy of a very extensive discussion, because the abolition of the ABCC, of course, is going to play into a circumstance where lots of building companies are placed under significant additional pressure because of the actions of bodies like the CFMEU and the increased pressure placed on those building companies because of the regulatory regime being removed. So I have to say that in the current climate...
Are you worried about the HBCF collapsing for that reason?
Well, I am worried about potentially increased number of claims on the HBCF because of increased pressures. You know, we have supply chain issues, we have liquidity issues in respect of a number of building, all of which play into potentially a circumstance where we do have.
So I'm asking you,
and it just gives rise to this, doesn't it? That if ever we were faced with the circumstances where you would not want to, in fact, place any additional pressures on the building industry by removing organisations like the like the ABCC, that now is the time to make sure that you didn't do that.
Maybe we should do this.
And I'll be calling on you, Mr. Mookie, to agitate with your colleagues federally that you do not go down that path, because the pathway forward, both for the state,
I'll give your request all the due consideration.
For the state, good. I'm glad you did that, but I think for the state and for the building industry
I will give
generally.
it all the due consideration it deserves.
Well, no. Well,
let's not.
You can say that, but
Minister,
it is a serious
I've been treating
issue.
this as a serious matter.
It's a serious issue.
I have been treating this as a serious matter when it comes to the HBCF in the current climate.
And perhaps, you should.
And perhaps you should too. So I'll go back to my question. What advice have you received about the HBCF's ability to cope with the collapse of one or more major builder in New South Wales?
Well, I'm satisfied that the fund is operated in a way where all building companies are regularly reviewed in terms of their ability to meet their commitments, and perhaps Mr. Harding would like to just expand on that, because
before he does, because we've only got 2 minutes, and then sadly our time has come to an end. It seems, Minister, which is disappointing. But I am interested specifically in whether or not your government has obtained reinsurance for the HBCF or not.
Does the government do that?
Mr. Mookie, we are...
Oh, we've got more time with each other.
No. We can have more time if you want.
Apparently.
12:45.
Yeah, but the 15 minutes.
Yeah, at 12:45.
At 12:45. You finish at 1, so...
Oh, okay.
Yeah. Mr. Mookie,
I'm relaxed.
Oh, that's right.
We're having so much fun.
We can tell.
The government hasn't in the past purchased reinsurance for the HBCF. I'm sure you can imagine that buying reinsurance at this point in time is not cost effective.
No, I agree with you in that, Mr. Harding.
What I can say in respect to your previous questions is now that we have pricing at a sustainable level, the sorts of volatility that is normally expected in the building industry, and it goes in cycles, is priced into the way we think about premiums. And whilst we have a funding ratio of 80%, obviously isn't yet at 100%, the scheme is robust and sustainable in that regard. So, multiple significant builders collapsing would clearly be challenging, but large builders, the scheme can absorb those, and we can work through.
Yeah, I appreciate the answer, Mr. Harding. in respect to reinsurance at current rates. I might ask the Minister, but I suspect that the Minister may need to take this on notice, or certainly Ikea might need to. But in 2018, was Ikea advised that reinsurance might be necessary for the HBCF?
You're right. I do need to take it on notice.
Yeah, I thought so. Does Mr Harding have any further information on that? I wouldn't suspect that he would. He wasn't there, but...
Look, it is a... I don't know what happened in 2018.
Yeah.
It is something that we think about. Again, it comes back to the cost effectiveness of it on a regular basis, right? Given that the scheme is underwritten and the tail of the scheme is underwritten, normally what you're worried about is the tail.
Yeah,
the tail of the scheme is underwritten by the New South Wales.
Mr Harding, I appreciate you taking it on notice. So just if you are going to take it on notice, and to the Minister as well, if we can take these specific questions on notice, it would be appreciated. The specific questions I'm interested in is, did Ikea undertake an analysis of the effect of a collapse of a major builder on the HBCF in 2018? Did that analysis yield a recommendation for Ikea and the government's consideration about obtaining reinsurance? Did Ikea then obtain that reinsurance? And if Ikea did not obtain that reinsurance, why were the reasons for Ikea not choosing to reinsure the HBCF in 2018? If it's possible, Minister, you could take those questions on notice.
You'd be surprised if I had the answers at my fingertips, wouldn't you?
I'd be astonished and full of praise for you, Minister, if you did. But in the event that you don't, do you mind taking those 4 questions on notice? I might pass to my colleague.
Minister, in the March budget estimates, we were discussing various dust diseases and afflictions and the way in which the legislation was constructed. And I think we discussed that a number of reviews had identified at least 5 diseases that weren't covered. I'm happy to say I found a regulation, or has been supplied to me, which indicates that 5 afflictions have been added, and that is good. But we also discussed the tragic nature of having to rely on historical experience to then identify these new afflictions, and then there's always a period of catch-up to add them to the list, and we did discuss the possibility of maybe flipping the way the legislation worked so it was sort of all-inclusive rather than having to sort of play catch-up all the time, and you indicated that you'd be happy to work with the Parliament in relation to that. Where have you gotten to over the last few months in terms of progressing that idea?
I acknowledge I made that concession, and I acknowledge that you identified at the time that it sounded like a good idea. I think there is a bill, obviously, before the Parliament at the moment. I think we have, in fact, achieved a significant outcome by identifying the 5 additional. I haven't been advised currently that we need to actually reverse the process so that these are in fact added when they're identified. Can I still maintain my position that I think it's an ongoing discussion?
Okay. We also discussed the possibility of mandatory health screening in the installed sort of stone industry, and for example, it's done in the coal mining industry. Coal services very successfully operate, so compulsory health screening.
I think we talked about the van and these.
We did, and I think you said that, look, data of that kind would certainly inform the process, but you didn't know whether we were at that stage where it was sort of warranted. That's at page 10 of the transcript at the top. Are you advised, is there like a number of victims at which the sort of the threshold tips where the government would be convinced to do mandatory health screening, or is this something you're working on?
It's interesting you raised this because I met with Unions New South Wales, or my office met with Unions New South Wales to discuss this this issue. Might have been a fortnight ago.
I'm unaware of that, so please tell us.
And in fact, I think we are just we gave them, I think at the time, a commitment that we'd explore other testing options and other data collection options which would be available. So that's ongoing. There is some additional work. Is there any other testing opportunities? We certainly have the mobile van testing.
Well, we currently have the Pitt Street office and mobile van. We are investing in a second mobile van, and we're relocating the Pitt Street office to Kent Street so that the costs are reduced and we can more actively manage the process. We have done, in respect to silicosis, we have done a lot more screening. We've had regular contact with the major provider, Caesarstone, and over 800 workers have been screened there since the last time we spoke.
So since March?
Yes, I believe so.
Not a trick question, I think. Fairly safe.
So it is an ongoing process of making sure we get as much coverage as possible. The issue of the mandatory nature of it is an issue for the government.
Sure. I mean, one of the other things we discussed, which I think has been identified in other reviews and is being taken up in other states, is the idea of registration. And I think we discussed this issue as well. Minister, where is the government up to with the notion of registration? Is it something you've rejected? Is it something you're still considering?
I haven't rejected it.
Okay. May we hopefully infer that this is something that you're still actively considering? For the benefit of Hansard, the Minister has nodded. Yes, okay. Well, that is very good. Okay, well, all right. In relation to health and safety standards, there are, I think, 11 exemptions that Safe Work has granted where, for example, one example is audiometric testing of workers frequently required to use PPE in workplaces with noise levels that exceed the exposure standard for noise. And obviously, by exposing workers to above standard health risks such as to noise is inexorably going to lead to more health problems and therefore more pressures on the workers' comp scheme and again pressures on premiums. Why is the government continuing to grant those health exemptions? So as I said, there's one on hearing, I think there's one on lead testing, there's one on hazardous chemicals. I mean, all of these are taking a risk with health and safety of workers, aren't they?
And in fact, that's the position. WorkSafe stuff is Minister Nominello's.
I understand that, but again, you're the Minister
the point you make is the potential impact on workers' compensation premiums.
And for your benefit, Minister, I think these exemptions have only been granted, I think, since 2016.
I get the point, and I think it probably is worthy of a broader discussion around with the Work Safety Minister about the circumstances under which those exemptions are provided. I'm not sure that we're ever briefed in respect of it. Maybe the point is that if there is to be an exemption granted by WorkSafe, then perhaps we ought be. I'm not sure whether Ikea gets briefed in respect of work safety exemptions.
Depending on the nature of them at the time, if they're broad-based, yes. In the hearing one, we've seen significant escalation in hearing loss claims, but in recent time. But whether the exemptions played a part in that, I can't tell you.
Right, so, I mean, it seems like a logical proposition that it's hard enough to enforce safety standards, but if you allow workplaces to operate, shall we say, in excess of those standards, you're just inviting risk, aren't you?
Yeah, but in fact, Mr. Silver, I have to say that given the synergy which exists between WorkSafe and Ikea, I've often thought it curious that the Ikea minister responsible for Ikea isn't also responsible for WorkSafe.
I've often reflected on that strangeness myself, Minister.
Because I think it allows us to talk to employers about their work environment from a work and safety perspective, and potentially reduce premiums with a view to the manner in which individual workplaces comply with work safety requirements. So that's just a idle reflection. But
I think there's a lot of sense in that, Minister. Minister, through you, just go back to Mr. Harding. You indicated that hearing claims had escalated. Can you tell us how much they've escalated?
I don't have the data with me. I can get it on notice if you'd like.
Yeah, if you could on notice provide, say, the last 3 years to see whether or not we can see a pattern. Do you have any figures with you at all, like any numbers or?
my bad habit is to try and give you stuff on the top of my head.
No, that's
so
fine.
I'd rather give it to you on notice if that's all right.
Yep, okay. And do you know if there's any pattern in the claims about geographical patterns, such as where people might live or where they might work, or?
Without using a commonly used term, there is some element of particular lawyers being involved.
Is it broken down by occupation or by background?
I can provide it with some element of granularity around occupation in the claim numbers, but the pattern isn't necessarily occupation related as much as it's related to the practices of particular law firms.
Okay, so in relation to silicosis screening, I think there's been New South Wales hasn't undertaken the same sort of case-finding studies as Queensland and Victoria. I think you've got a firm called Golder Associates that have done it, but they've done it sort of triangulating existing data held by Health, Safe Work and iCare rather than sort of conducting their own investigations. And the Royal College of Physicians has indicated that without that sort of proper interrogation, you're not going to get the right data. Is that something that, as Minister, you're reflecting on?
Again, it would be something that we would work with iCare on, because data obviously is, in many respects, the key to probably addressing the issue. So.
Yeah. Mr Harding, do you have anything to add to that?
No, I agree with the Minister.
Okay, so do you have any reflection on the methodology used by Golders Associates to do that?
Specifically, I don't.
Are you happy to take that on notice and to go back and to give us an answer?
Sure.
Okay, that'd be good. When we were talking about making sure we identified all the people who might be at risk, I think, Minister, you indicated at estimates last year that silicosis screening and identification of workers was a bit hit and miss. I think Mr Harding also indicated that you relied on information from Safe Work, there was input from unions. Obviously, you're working with responsible employers, but it's an ongoing process to keep identifying people who are exposed. Registration is obviously something that would go a long way towards fixing that.
Yeah.
I mean, what is it going to take to sort of push the New South Wales government to sort of taking a more systematic approach to identification of people at risk in New South Wales?
Again, I'd probably take that on notice. I think whether registration is the right answer or whether awareness campaigns or the like are potentially part of the answer. I don't know. See, we have individual specific locations where silicosis is potentially a problem, but in an individual building site, and every individual building site, could be issues arising in respect of potential silicosis sites. So whether registration solves the problem where we would need to identify every single potential silicosis building site,
But it would certainly
maybe the subject of an awareness campaign, and perhaps even that a component of that would be to have building sites and the like avail themselves of the use of the silicosis bus for testing facility. These are just sort of a bit thought bubblish, but it strikes me. I was on a site there recently, and there were people cutting kitchen tops on the site, and that site, in my view, it gave rise to was a safe work issue, but B, was there a silicosis awareness issue?
Okay, I just had one further question, which was in October 2019, you were very aware of the need for CT scans to detect silicosis, and you said that issue was front and centre for you, and yet today, iCare's initial screening still uses an X-ray, not a CT scan. When will you move to CT scans? WA has done it, so why can't you?
We are moving that way. So to create the mobility of the lung bus and to enable us to get out and actually screen people, a CT scan is not feasible in that environment. So we prefer to start with the standard form of screening. What I can say, though, is we do also, when we identify through that screening someone who has potential exposure, we encourage and recommend that they all go to their local place, whatever you want to call it, to get a CT scan as a matter of course. So that is, of course, we can't enforce that. That is a matter of us recommending it, but to enable us to do the mobility of actually being out in the community and out in workplaces, the trade-off is partly that you can't do that with a CT scan. You know, it's just not feasible. But we do ensure that everyone who's identified knows they have to have a CT scan to follow it up.
Thank you. That's the end of time for the opposition and crossbench. The government.
Yes, just one question, Chair. Thank you, Minister, for appearing today. Wanted to ask if you could provide an update on your efforts to facilitate a new enterprise agreement with the RTBU.
Shocker.
Please tell us, Minister.
It's difficult to facilitate an outcome with a union that doesn't want to, in fact, reach an agreement. I would be delighted if I could walk out of here. I know there's a meeting happening later today, hopefully to finalise a document which will satisfy the RTBU in relation to the government's commitment to carry out work on a perfectly safe train to satisfy a union demand. Now, as outrageous as that is, it is the price that the government is prepared to pay for the purposes of trying to make sure that the economy of the state is serviced and not vandalised by a union which seems intent on vandalising every single business in this state, vandalising every student in the state in getting to and from school and the like. So where we are at the moment is we're faced with a political campaign, and really I think there are some levers which we need to do to understand exactly what is driving this. And I've heard the leader of the opposition in this state regularly saying get people in a room and get them to solve it. Well, I think he needs to actually come clean on this and say to what extent he's coordinating it. There is no doubt, in my view, that there is a level of coordination between New South Wales Labor and this union for the purposes of making sure that the commuters of this state are held to ransom as a result of this industrial activity. And you only have to see a circumstance where every new member joining the upper house or previously, in my experience, the lower house gets up and thanks their friends in the union movement to know.
Point of order. Come on. Nice try, Minister. You've got to actually be directly relevant to the question that was asked. Now you're just getting into a whole range of other issues that have nothing to do actually with the question that the Honourable Chris Ruth very kindly asked you. So
I'll uphold the point of order, Minister. You have to be directly relevant.
Just about to mention Alex Classen's name.
Well, it's got to be directly relevant.
Further question in government time. Is there anything further you'd like to add, Minister, about the link between New South Wales Labor and the RTBU that, in your opinion, might be stalling the finalisation of an agreement, a new enterprise agreement?
Yeah, and I'm grateful for that question, because it is clear that if New South Wales Labor had an interest in resolving this issue, they would have been much more involved in wanting to come out and condemn the actions of the union movement. This is a union movement who regularly wears Labor T-shirts at election campaigns, who sit on campaign committees for the Labor Party, who regularly meet with the Leader of the Opposition in terms of working out what tactics ought to be adopted for the purposes of running the agenda for the Labor Party in the state. So I have to say that trying to reach an outcome with this union is against a background where there is a political agenda at play, and that the extent to which reaching an enterprise agreement with the union and reaching an understanding which will bring to an end industrial activity is being hampered by the industrial and political outcomes which the Labor Party in this state have in their sights. So what I think we ought to be doing today is to call on those who meet with the RTBU, tell us when you're meeting, tell us what the discussion's about, give us an insight into what directions that you're giving to the RTBU in relation to conducting this industrial activity. Maybe then we can get some industrial peace and get some outcomes for the commuters of this state.
Here. Thank you, Minister.
What a shame. We've come to the conclusion of this morning's proceedings. You are now excused, Minister. We've completed our questions with you. Everybody else, we will see you back after the lunch break at 2 p.m.
Thank you very much.
Welcome back, everybody. We'll continue our questioning with the opposition.
Thank you, Chair. Thank you, Mr Secretary, and your officials for your return. One should never take these things for granted.
This invites a white lie where I say we're happy to be here.
Just as happy as I am to be asking you, Secretary, I'm sure. Can we just start with a couple of questions in respect to the rail dispute? Do we have, firstly, the costs of the application that was made in February to seek a termination of the bargaining agreement that was incurred by the public?
No, we don't have it to hand, but we can take that on notice and respond to you, Mr Mookie.
Thank you. Do you also have the cost of the application that was made in May to terminate the bargaining period?
No, again, happy to take it on notice and respond.
How many barristers did we utilise in the May proceeding?
There was 2. So I might invite my colleague, Mr Houston.
Certainly in the July proceedings, there were 2.
Is it possible that we could use the microphones?
We thought we were, sorry.
You might need to pull it closer.
Oh, okay,
Some
sure.
of them are a little better than others. Yeah.
Sorry, I didn't hear that. How many?
He's very softly
2.
spoken.
And who were they?
It was Kylie Nomchong and Haren Harajasingham.
And what rank are they?
Kylie Nomchong is senior counsel.
Yep.
And Haren was a junior.
And have we retained any solicitors firms to assist in this dispute?
No, we engaged the Crown Solicitor's Office.
Yep. Secretary, by any chance, have you read the decision from the May proceeding?
Look, I did skim it.
Were you surprised when the Commission described your evidence as being unconvincing and highly unpersuasive? And does that create any concern for you?
Well, look, on the face of it, yes. The question is, was there something we could have done to better communicate the information we had available to us? And I think there are possibly some lessons learnt there that you need to more specifically identify the quantified impact of each element of protected industrial action. So we have considered that. I mean, to the question of the broader question of the value or sense of making that intervention, it did have the impact of seeing a number of notified protected industrial actions withdrawn, most notably on the metro system. So it had the effect of preventing what would otherwise have been costly disruptions.
But, Secretary, you do accept that in all but name, the Commissioner felt that your claims were exaggerated, unpersuasive and not supported by evidence?
As I read it, we weren't able to, our advocates weren't able to adequately explain the assumptions behind the calculations.
Do you by any chance happen to have the cost to date involving all proceedings in the New South Wales Industrial Relations Commission as it involves a dispute with the New South Wales Teachers Federation?
Gosh no, but we can take that on notice.
Can you also take on notice the same cost figures for all disputes involving the New South Wales Nurses Association?
Yes, okay.
Thank you. Are you contemplating seeking orders in the Industrial Relations Commission ahead of any action that may or may not be taking place next week from the New South Wales Nurses Association?
I thought that we had sought orders and obtained them.
Orders were made yesterday against the Nurses Association in relation to the planned strike action on the 1st of September.
Yeah. Secretary, in respect to when were you asked to prepare advice or the legislation that has been presented to the Upper House in respects to the fines issues for industrial organisations?
I would need to call on my colleague, Mr Houston, for his best recollection.
I would have to take that on notice.
So, well, when did you draft the legislation?
It's not a matter I know off the top of my head.
Yeah, we'll take it on notice and give you a chronology if you want.
What impact are you expecting that legislation to have on the rail dispute?
Well, noting that the matter is currently before Parliament. However, it relates to matters within the state jurisdiction.
Yeah.
So no, in
Note
fact?
that the rail dispute is a matter within the federal jurisdiction.
Yeah.
Indeed, and so therefore it will have no effect.
Don't expect so.
Okay, thank you. And in respect to how many fines are currently outstanding against the New South Wales Nurses Association? And what are the value of those fines?
I'll take that on notice.
And how much are currently outstanding against the New South Wales Teachers Federation?
There are matters that are currently live before the courts.
We've issued the fines, haven't we? Or we sought the orders? We sought to enforce it.
Applications have been made but are not yet being concluded.
Okay, where is that proceeding up to? When was the application made?
I'll have to take that on notice, but there are a number of matters about contravention of orders made by the Industrial Relations Commission which have been made but not yet concluded.
How much have we collected in fines in the last 12 months from registered industrial organisations of any type?
I'll have to take that on notice, Mr. Moore.
Okay. Can we also get on notice a list of the registered industrial organisations that have paid those fines or have those fines outstanding?
Certainly.
Thank you very much as well. Secretary, through you to Mr Harding, if that's possible.
Yes.
Mr Harding, did you have any further information you wanted to add from questioning this morning that you didn't have the opportunity to put onto the record?
I would like to talk, Mr Mookie, about the conversation you were having about TMF, if that's possible.
Indeed. I do have, yes, in fact, but before we do it, because I did want to ask you some questions about the TMF, can I first invite you also to perhaps move the microphone just a little bit closer?
Yep, no problem.
Thank you. I didn't get the opportunity to ask you this morning about what precisely was the net result for the TMF last year. Did you have that figure to hand?
Yes.
What is it?
So the TMF had a loss of $317 million.
So, and that's a reversal from the $782.4 million positive number in the previous year, correct?
Yes.
So again, that's another $1 billion deterioration on the net result?
Well, I think you've got to come to understand how insurance works, Mr Mookie.
I'm sure you very soon will explain it to me, but let me just do the maths first. That's
Well, in an absolute, very simple manner, yes.
Thank you. And what is the current funding ratio central estimate for the TMF?
The insurance funding ratio is 124%.
No, I asked you the funding ratio central estimate.
They're all funding ratios, Mr Mookie.
I'm just, Mr Harding, asking you exactly...
The accounting ratio for the TMF is 106%, Mr Mookie.
Thank you. And what did you say the insurance ratio was? 124%.
And
what exactly are the investment funds under management for the TMF?
$14.3 billion in assets.
And what was the investment return last year for the TMF?
I don't have that in front. Yes, I do. No, I don't.
You mind taking that on notice?
I'm happy to take it on notice. It's obviously a negative return.
And do you have access to currently the investment benchmark for the TMF?
Well, the investment benchmark for the TMF is a long-term benchmark.
Yeah, is it still 17.6%?
No, I don't believe it was ever 17.6%, Mr. Mookie.
Well, let me read from the annual report from last year, which was on page 40. This investment benchmark, TMF only, 17.6%.
That may have been that current year's performance.
No,
the investment market goes up and down. What the benchmark actually is, Mr. Mookie, will be a factor of CPI plus a percentage, AWE plus a percentage.
Just to be clear, Mr. Harding, your annual report last year listed investment return, TMF, at 17.9 and investment benchmark at 17.6.
Yes, that would have been the performance of the benchmark, Mr. Mookie, not what the benchmark is.
Okay, thank you. So thank you for clarifying. If you can on notice, tell me what the current status are in respect to those figures, that would be appreciated. But it's fair to say that in the last year, the insurance ratio went from 141% to 121%, and your accounting ratio went from 111 to 106, but it got to as low as 102 earlier this year, did it not?
Yes, Mr. Mookie.
And is that what put you in, when I say you, I mean, that's what put the TMF in breach of the net asset holding policy, did it not?
Yes, and that's the policy that governs how the TMF works, Mr Mookie.
It is, and in fact that policy was revised, I think, prior to your appointment as CEO, from requiring a minimum of 115% down to 105. That's correct.
No, the minimum has always been 105.
Well, your two of your
Can I finish, please, Mr Mookie?
Well,
the minimum has always been 105. There was 115 was the point at which the government made it, or the Treasury made a decision as to whether to withdraw funds from the TMF, not put money into the TMF. So the range was between 105 and 115%.
Thank you for
and
clarifying.
we removed the cap.
When did it get to 102?
Earlier in the year and in around December. But perhaps if we talk about the NAHLP, Mr Mookie, because that is the fundamental basis on which the self-insurance scheme works.
Before we do, did you say that the 102 was reached towards the end of last year?
Yes, it would have been after we did the December valuation, Mr Mookie, which would have been in January time.
Yeah, and was that the lowest it reached last year?
I would have to take that on notice.
Okay, thank you. And you were just about to explain to me how insurance works.
Well, no, it's actually because this is not insurance.
Okay, well, what do you wish to explain?
This is the NAHLP, which is the government's policy for how it manages the TMF.
Indeed.
And the TMF is a very different fund to the NI, for example.
You made the point to me earlier, Mr Harding, that you wish to explain to me various things about how insurance works. So I'm going to give you the opportunity to explain to me how insurance works in whichever respect you like.
Let's start with the TMF and then we can move on to insurance.
Please.
With respect to the TMF is the government's shock absorber for the activities that it undertakes on a day-to-day basis. And over time, the NAHLP, net asset holding level policy, governs the funding of the shock absorber. So if we incur events such as natural disasters or changes in the nature of the scheme, such as the Parliament's decision to enable the Civil Liabilities Act to provide access for victims of child abuse to common law, these things all affect the claims that then the TMF incurs. Over the last 12 months, we have seen a significant, obviously, number of events that have incurred in terms of the flood events. And correctly, the Treasurer talked to about $400 million worth of claims arising from the flood events. But that is not alone what has caused the need for an injection. There is also the impact on the workers' compensation scheme that you rightly pointed out earlier, of the increase in psychological claims. And psychological claims in the public sector are now almost at the rate of 1 in 4, heading towards 1 in 3 new claims coming into the scheme. As you would be aware, psychological claims cost about 6 times more than a physical claim and have a significant impact on the duration of claims in the scheme. We also, as I mentioned, the Civil Liabilities Act changes in access to common law for victims of historical child abuse. That has added about $600 million to the claims resulting from that scheme. Further, there's about another $280 million relevant to increases in medical malpractice claims arising through the stresses that are being experienced in the health system. On top of that, Mr Mookie, you'll no doubt be aware that the investment markets moved to the tune of $858 million in terms of negative against the scheme. And further, wage inflation has shifted, which has had an impact on the workers' compensation scheme of around about $300 million. So there are a number of external factors and factors that are actually in the nature of the scheme itself, the reason this scheme exists. If we go back in time, Mr Mookie, certainly the last 5 years have been intense. As you rightly pointed out, almost $4 billion of injections into the scheme. Interestingly, though, if we look at the previous 5 years, the scheme paid $1.6 billion back to the government. The previous 5 years before that, there was a requirement of around $2 billion of injections. The previous 5 years before that, the scheme further paid back to the government and to the Treasury $2.1 billion. So it is in the nature of how the scheme works, and to characterise it any other way is quite unnecessary.
Mr Harding, I appreciate your explanation. It's almost word for word identical to the explanation I heard from one of your predecessors when they first $2 billion.
That'd be because this is how the scheme works, Mr Mookie.
Mr Harding, perhaps just let me put the question to you. Given that the factors that you just described were all the same factors, almost identical in terms of what you described, to what caused Treasurer Perrottet to have to authorise a up to $4 billion injection in 2020, of which $2 billion was accessed.
It was a $2 billion injection, Mr. Mookie.
Glad you heard me correctly, Mr. Harding. Given that these factors are identical, you're honestly telling me that none of this has anything to do with the fact that you've presided over, once more, a collapse in return to work rates. You're telling me that has nothing to do with it?
Well, Mr. Mookie, return to work rates have nothing to do with either investment markets, wage inflation, floods, storms, or, for that matter, child abuse claims. All of these things are, in fact, the activities of the New South Wales government, and that's what the TMF is here to support. To suggest that we're doing anything otherwise than supporting the activities, as the Minister said earlier today, rebuilding hospitals and schools, ensuring we support the health system at a time in need through malpractice claims, ensuring that we delicately treat the issue of child abuse, historical child abuse, through the redress scheme and through the system there, making sure that we actually get people back on track. Those are the reasons that the TMF exists, and those are the reasons that we need $1.9 billion. As I've just painted to you, it's very much a natural part of the history. Each year we sit down with Treasury and look at the status of the fund and whether there is funds to be withdrawn from the scheme or funds to be added to the scheme to make the scheme sustainable.
Let's appreciate that, Mr. Harding. If we don't mind, let's talk about the nominal insurers' return to work rates. Was it the case that in April 22, which is the last available data as put of the regulator, your return to work rates at the 13-week level was 75%?
The April 22 data? I have 78%, Mr. Mookie, for the rolling 12-month SIRA data.
Well, that's what they say on their website, that particular month it was at 75.
Well, I'm sorry, my notes say 78, but I'm happy to work with your number if you prefer. Let's work with that.
Oh, I appreciate that, Mr. Harding. Was it the case that in May 18 it was at 83?
No, I'm afraid I don't have numbers going back to May 18.
Well, the SIRA website does, and it says it was at 83. And when did you become CEO?
In January of 21.
What was it at January 21?
It was around 79. December 2020, it was 79. March 21, it was still at 79.
So why has it gone from 79 to 75 on your watch?
Well, there is actually a very good explanation for this, Mr. Mookie, that goes back to 2006. So we have recently had some research conducted by Professor John Buchanan of the University of Sydney, who I believe you're well acquainted with, but Professor Buchanan is one of the preeminent members of our labour market and health.
I know he is.
And what we look at when we look at the longitudinal study is that actually return to work has been on a decline since 2006. And there are significant shifts in the nature of the labour market and the economy that have driven this. Obviously, we've seen a move away from manufacturing into services industries. The biggest employment growth in that period has been in health and community services. The second biggest employment growth has been in education. And in the third largest employment growth is actually in the area of professional services. Now, health and community services, the rate of psychological claims in the health and community services is double the next closest rate of claims. And we are seeing significant impact to the scheme as a result of this overall change. That combined with, logically, the changes that have been more recently seen in the community from COVID, working in different ways from home, etc., as well as the 24-hour, 24/7 technology economy that we're in. All of these things are having an impact. The other issue that Professor Buchanan has identified is that there has been a significant drop in the engagement in employers in return to work of psychological claims. We know that when an employer is actively engaged in the return to work activities of an individual, especially in respect to psychological claims, that we get a 20 to 25% improvement in return to work. Mr. Buchanan, Professor Buchanan's work has identified that has dropped significantly, around about 15% in the last few years. Possibly as a result of COVID, we don't have a causal analysis yet. All of these factors have gone to why return to work has declined over the last short period of time, or the last 10 years, and we are always looking towards improving return to work. I'm happy to tell you, Mr. Mookie, that in more recent periods, if we look at the 4 and 13-week rate, and we look at it in a shorter time frame than the 12-month rolling average, that we have seen significant improvements. So the 4-week rate, the 3-month rolling, as of April was 62.6% and now at 66.7%. Sorry, as of December, 62.6, now at 66.7% as of May. As the 13-week rate was at 77.8 in December, is now at 80.3. So we are seeing green shoots.
Mr. Harding,
if I could just finish one last point.
I've let you speak for approximately 4 minutes straight.
I only have one last point to make, Mr. Mookie, which is quite important.
Well, I'd like to pick up on some of what you've said before.
Well, let me just finish, and then we can have.
It's fair enough to let him just finish.
If it's short.
It is very short. Our June valuation from the actuarial outcome included a release of $450 million as a result of these positive signs in return to work over the last 6 months. So we are seeing some green shoots. But as I have said to you all along, this is not a sprint. We're not going to see it, especially when you consider the changes since 2006. We're not going to see it turn around tomorrow. It is going to take concerted and long-term effort, which is why we're doing the work we're doing around the claims model. So I'll stop there and then let you ask your question.
Thank you. Mr. Harding, in respect to the two main points you just made, the first is about Mr. Buchanan's research. Again, I heard almost the exact same explanation, word from word, from your predecessor hours before he resigned, about technological change, workforce change. Equally, in respect to your other point about the green shoots recovery, I've heard multiple members people who've held your job before explain various ways in which we should be calculating this. And in fact, that led to tremendous disruption with the disputation with the regulator, which has been resolved. So, basically, is it your evidence that when it comes to the collapsing return to work rates that you've presided over, that your organisation are effectively blameless?
No, that's not what I said at all, Mr. Mookie. I said there are clearly a number of significant factors that are affecting return to work across the economy. This isn't a factor that's just affecting Ikea.
What's your target?
The rates of change have fallen in Victoria, to the extent that the Victorian government has contributed over $800 million in the last 2 years into the workers' compensation scheme to ensure its continued support. So we see in the UK, in fact, that these days,
I don't disagree with you, Mr. Harding.
is experiencing 1 in 2 of its workplace claims, workplace injury claims, as mental health claims. This is not something that's unique to Ikea.
I'm not suggesting it is.
Let me just finish again.
Well, Mr. Harding, you're not actually answering my question.
I am about to.
Well, perhaps we can try before we do the preamble. Perhaps a direct answer might be advisable. But just in respect, I do not dispute at all that workers' comp schemes in Australia and across the world are under pressure. But you're honestly suggesting to me...
Oh, if you let me finish, we are clearly also dealing with the issues that arose through Ikea and the claims model that was implemented in 2017 to 2019.
I am interested...
And we are in the process of undertaking a very significant transformation and remediation program to address those issues.
What target has the board imposed on you in terms of return to work rates?
I don't have those targets with me right now. The targets that were imposed or that were provided, that we agreed in the previous year, as I said to you in the last budget estimates, were in hindsight not relevant or achievable. I'm happy to give you...
What were they?
I don't have them with me. I'm happy to give you...
So the targets that the board signed you up for, in your view, were not, in hindsight, were not achievable? Is that what you said?
Nor relevant.
And so the board imposed irrelevant targets on you?
Well, the board didn't impose them, Mr. Mookie. I work collaboratively with the board.
But you agreed to an irrelevant set of targets?
I'm a member of the board, if you recall. I'm managing director.
But did you agree to irrelevant set of targets?
At the time, I didn't know what I know today, Mr. Mookie, and that's the nature of life.
So what are they now?
Well, I'm happy to get them for you on notice because we're just in the process of agreeing this coming year's target. So I'm happy to do that.
But I presume that the ones that you say now are relevant were not achieved.
Clearly, Mr. Wilkie, we just spent 15 minutes talking about the decline in return to work rate since 2006.
We did. So, is it still the case? What is the operational break-even premium?
It's 1.8.
Currently?
8. Well, yes, as of the last value. As of the last premium filing with Insurer, yes.
So, and currently the actual premium is 1.52, isn't it? Or am I wrong?
Approximately, yes.
It's at 1.52 and your break-even target, operational break-even, is at 1.8. Do you have a forecast as to what that's going to be in 12 months' time?
No, Mr. Mookie, because we need to take into account all of the factors that we just discussed and look at the premium filing on its face at that point in time when we get to the next year's premium filing.
But it's 0.28. The operational break-even point is 0.28 higher than the current, correct?
Mr. Mookie, I think we've been on record before saying to you that the premiums need to go up. The fact is how to do that over time in an appropriate manner,
what I'm alarmed
in a staged way to get to where we need to be in 10 years' time. This is a long tail scheme, and as we've talked about looking at investment returns, whether we talk about looking at wage inflation, all of these factors need to be thought about in the long term. If you respond to the short-term volatility, then we'll have very different issues for employers experiencing spikes in pricing. Our goal is to manage that over time and to be very clear. Well, we've not shied away from the fact that premium rates need to increase.
And
They've
I appreciate your candour.
8 years of being flat.
And Mr. Harding, I do commend you on your candour in that respect, because to be fair, your predecessors were not as candid as you are, and I respect you for doing it. But it is the case that with an operational break-even premium of 1.8 and the current premium set at 1.52, given the fact that your liabilities exceed your assets, there's no way that any of the 328,000 small businesses that pay into your fund should expect anything but premium increases for year after year after year. That's correct?
Mr. Mookie, as I just said, we have always, since I started, talked about the fact that we need to manage all 4 levers of the scheme. And I have always said to you that premiums need to increase. The key here is doing it in a way where we don't knee-jerk react to short-term cyclical changes, that we actually tackle it on a long-term deliberate basis, and that we look at it each year, we set it each year with a view to that long-term outcome, and we manage it towards the ultimate goal of getting to the break-even premium.
That 1.82 as of the 30 June 22 valuation?
It would have been as the filing that we made with Insurer, Mr. Mookie, which would have been January this year or probably March this year.
So the equivalent break-even premium for the period last year was 1.77. So the operational break-even premium has gone up, even within 12 months. So it's not like we're getting closer. We're actually getting further away to what the premium point of collection is equal to.
This points to the point I'm making about looking at it over the long term. You need to not react to short-term changes.
Mr. Harding, I'm trying to give you the opportunity.
As at 30 June, Mr. Mookie, the break-even premium rate went down. I just don't have it off the top of my head. But, that short-term volatility between December and June is exactly what I'm talking about not reacting to. We need to manage it on a long-term basis to get to a long-term outcome.
And I appreciate that you do for a long-tail scheme, but every indication we have is that over the long term, short-term, medium-term, this scheme's performance is getting worse. No matter how you cut it. It's getting worse. We've lost another $1 billion. The operational break-even premium's gone up again. Return to work rates is collapsing once more. Can you give me any information or any data whatsoever that would suggest that in respect to any of these?
I've just talked to you about improvement in return to work rates since December this year. That is giving us some positive.
Your internal method of calculating that.
No, there's a Insurer-based data just looking at on a different smoothing, Mr. Mookie, because when you look at a 12-month rolling average, you're not actually getting a lot of short-term change being seen in that, are you? So look at it at a 3-month rolling average, you get to actually see what's happening in the scheme.
Mr. Harding, do you sit on the remuneration committee of your board?
The chair is Miss Elizabeth Carr. The other members are the Chairman, John Robertson, and his name's just left my head. Mark. Thank you, Mark Goodsall.
When are you taking your recommendations for the payment of any short-term or long-term incentives to that committee?
Over the next month, Mr. Mookie. And
have you prepared your report?
There is an ongoing conversation that we've had with the board about our remuneration.
Are you recommending the payment of bonuses to the 200 or about 150 staff that last time we checked were entitled to them?
118. The conversation is ongoing and it's a matter for the board.
It is, but you are the managing director. You get to bring the recommendations.
Well, in this case, it's a matter where I'm conflicted, Mr. Mookie, but...
well, you are in respect to yours, but not in respect to everybody else, including your direct reports.
The board is having an ongoing conversation, and when the board's finished its deliberations, I'm sure you can ask Mr. Roberts.
Oh, I will.
But it's not appropriate for me at this stage to tell you what the board's deliberations are.
I'm not asking you to tell me what the board's deliberations are, especially given the board hasn't deliberated. I'm asking you, are you intending to recommend to that committee that they approve the payment of bonuses to any staff at Ikea?
Let me answer it this way, Mr. Mookie. So there are a number of different options being provided to the board about remuneration structures and outcomes that they are considering.
Well, given that you have said that at least in respect to your own targets, they are now in hindsight irrelevant, on what basis do you see, given also that your organisation has lost $1 billion in the NIs and required a $1.9 billion injection for the TMF, having lost nearly $1 billion in that fund, what performance do you think your executives have engaged in which would warrant the payment of a short-term incentive?
Well, Mr. Mookie, I'm not going to conduct a performance review on my executives with you. That's the job for me and my team and for the board.
Thanks. See ya. Hello. I wanted to ask, I don't have a lot of questions, by the way, but I do have some. I wanted to go back to the electric vehicles issue. Yes. Is that you, Mr. Johnson?
Yes, I'll try and help.
Thank you. So I wanted to, we talked about the stamp duty exemption, and I'm just wondering, was there actually a target for how many applications that you thought you would get?
If I could have one moment. Could I start with the response from this morning where I didn't have around the objections, just while I get to my... because the question, my understanding was how many objections and what was the outcome. So we had received 59 objections related to electric vehicles. Of those, 40 were for the rebate and 19 were for the duty exemption. 7 were allowed and 51 were disallowed, and one's yet to be determined. Presume the reasons for why they were disallowed were similar to why the initial applications were. They were either used vehicles over the cap or was a leased vehicle.
And is there any consideration of changing the criteria? I know you said that the criteria hadn't changed, but in terms of encouraging uptake, so is there any consideration of either hybrids or electric vehicles?
I think that's a question for the government or Treasury. Our function in revenues, the administration of it. So.
No, that's great. Okay, but are you able to tell me whether there was a target in relation to the exemptions?
So for vehicles registered after the 1st of September 2021, there was rebates for the first 25,000 new battery electric vehicles and hydrogen fuel cell vehicles. So there was a maximum amount.
And that was within the financial year? Is that or is that over the whole program?
I believe that was over the course of the program, but I'll confirm. I hopefully be able to get that answer quickly.
Yeah, that was great. Yeah, because what I'm trying to understand is what was your yearly target? Are you meeting the target?
So We haven't been set a specific target other than there was an allocation of so many positions. They're not. There's still 22,002 available of the 25,000 as of the 30th of June.
This may be an obvious question, but what is the program time limited, or is that so? The 25,000. If you're saying there's 22,000 left,
yes.
Is that over a period of time, or is it just until we get to the 22,000 the program exists?
So I will confirm. My understanding was the first 25,000 that took access to it, and once that was exhausted, the program ended.
Okay, so then in that case, what I'm after then is what is the anticipated time frame of getting to the 25,000?
Okay, I'll take that on notice and come back to you.
That's fine. Thank you. And so we asked about, sorry, I'm just looking at, I asked you about the stamp duty exemption. Can I just ask you similar questions in relation to the actual rebate? So how many applications for the rebate have been made? I assume it's the same as for the stamp duty, is it?
No, so duty, sorry, we've had 3,275 application for the rebates.
Yep.
With 2,810 paid, which is, I think I said that this morning.
Yeah, you did.
Now the
That's
duty,
right.
so the duty exemptions is different. I'll just say those numbers
okay. So
as
I think
well.
we've been in cross purposes. I thought I was asking about the stamp. Whichever one I was asking, can you give me the figures for the other one? That would be great.
So I spoke of the rebate previously. Now the duty exemption, we've had 4,295 applications for EV exemption refunds with 3,902 paid.
Right. Okay, thank you. I think we've had those reversed, so no, that's fine, because I thought I was asking about the stamp duty this morning. Anyway, that's all right. My final lot of questions, and look, it may be that you have to actually take these on notice, is I wanted to ask about, let me pull it up. Wanted to get some idea about the difficulty with payment issues that people are having in the context of increased cost of living and things are difficult. And I wanted to understand, I suppose, getting the figures. I assume you do them via financial year rather than calendar year?
Yes, well,
so I'm looking, basically what I'm asking, what I want to understand is what the breakdown of the figures are, and ideally perhaps over the last 3 years, which is, how many applications for difficulty with payment have there been? How many people have been put on a payment plan? How many on a work development order? How many have had a fine reduction, or how many have had a debt write-off? I accept that you're probably not able to actually give those to me straight away.
No, but I can provide that on notice.
Thank you. That's it for me. So,
Can I just ask two quick questions, Mr. Harding, and you can take this on notice if you need to, but one general question, does Ikea regularly meet with Safe Work?
Yes, we do.
How often would those meetings occur? Are they scheduled? How many have happened over the course of, say, the last year?
Look, I used to attend them myself, but priorities have gotten in the way. We meet fairly regularly. I'm going to say quarterly at least, but I can come back to you with a more definitive answer.
Yeah, that's fine. And are they?
They are scheduled. And normally the secretary and I, or the deputy secretary and I, attend when we can.
Thank you. And are they just regularly scheduled, say quarterly, if that's what it is, in general terms, or would they have particular topics?
No, we have a standard agenda that covers through pretty much everything from most of the things we've talked about this morning, including dust disease, HBCF, through workers' compensation schemes.
And so you say sometimes you attend. Who are the other attendees for both your organisation and Safe Work?
So from my organisation, it will be the General Manager of Workers' Compensation, Group Executive for Workers' Compensation, our Group Executive for the Office of the CEO, which looks after our corporate affairs, so all of the government relations side of things, myself, if I'm there, also the Group Executive for the TMF, so including the HBCF. So we all generally try and get there. And on the other side is generally the relevant executive directors or so forth for different parts of safe work.
Could you be a bit more specific about that? You can take it on notice.
I can take it on notice, yeah.
Thank you. Okay. Does the government have any other questions?
I might just ask, if that's all right, if there's anything that's been raised today, whether it's this morning session or this afternoon session, that you'd like to revisit and elucidate upon? Clarify? Nothing? No? All good? Thank you for your time.
Thank you.
Thank you, everybody, for your time. So a number of questions were taken on notice today. The Secretary will be in touch to give you the timetable for responses, but they are due in 21 days. And thank you all very much for your attendance.
Thank you, Chair.